the court permission, I would like to display police report by sharing the screen.
Mr. Ahmad, can you see this document?
Yes.
Is it visibly clear to you?
Yes.
Can you please identify this document?
This is the police report number Telupit/00101/21 dated 5th April 2021 that was made by Mr. Richard Lee at the Telupit Police Department at about 2 p.m.
We'd like to put on record that the second prosecution's witness has identified this document as the police report number Telupit/00101/21 dated 5th April 2021, previously tendered by the lead counsel for the prosecution as Exhibit P6. Mr. Ahmad, can you explain what this document actually states, this police report?
It states on 5th of April 2021 at about 9 a.m., Mr. Richard Lee and the 3 other forest officers had operated the UAV for 15 to 20 minutes and noticed the illegal logging activity around 9:20 a.m. They arrived at the scene after 30 minutes. Also, Mr. Mark Angus and 4 other workers were arrested. It also specified the items that were seized.
Mr. Ahmad, will you be able to identify the photos which you say you received from Mr. Richard Lee?
Yes, I can identify them.
Tuan, with the court's permission, we request the 5 photos that were previously tendered as ID 5.
Yes.
Much obliged, Tuan. Mr. Ahmad, can you see these photos? Instructing solicitor, please scroll all the way down. Make sure the witness can see everything. Mr. Ahmad, are all of these photos visibly clear to you? Can you see them?
Yes, Counsel.
Can you please identify these photos?
I identified them as the printed photos of the scene at Tangkula Forest Reserve taken by Mr. Awang Ahmad Awang Ibrahim.
We'd like to put on record that the second prosecution's witness has successfully identified exhibit ID 5, which he received from Mr. Richard Lee. Mr. Ahmad, if I were to show you the fake permit that you received from Mr. Richard Lee, will you be able to identify it?
Yes.
With the court's permission, we request the fake permit titled Form 11A, dated 10th March 2021, that was previously tendered as ID 3.
Yes.
The permission, I would like to display fake permit by sharing the screen.
Mr. Ahmad, is this document clear to you? Can you see everything clearly?
Yes.
Can you please identify this document?
This is the fake permit titled Form 11 capital A, dated 10th of March 2021 that I received from Mr. Richard Lee.
Mr. Ahmad, we'd like to put on record that the second prosecution's witness has successfully identified this document as the fake permit titled Form 11A, dated 10th March 2021, which he received from Mr. Richard Lee.
Noted.
Mr. Ahmad, in your witness statement, you stated that the permit is fake. Can you explain to us why you made that statement?
It is within my ordinary scope of duty to determine the validity of these permits, and I'm able to identify it as a fake one from its first appearance. This because it does not specify the types of trees to be felled by the permit holder. In addition, at line 4 of the permit tendered, the word Simpan Tangkulap Kawasan was purposely added to show the area that forest produce can be taken, but instead it is in compliance with the statutory Form 11A.
After you found out this permit is actually fake, what did you do next?
To confirm, I contacted Harisa Marisa, the authorized signatory signing on behalf of the Chief Conservator from the Sabah Forestry Department, and also the person in charge for permit application, but she replied no application was ever received by her or the department, and no permit was being issued at all. On the 12th of April 2021, I've contacted Eunice Malis to further verification, and the response is similar.
Mr. Ahmad, in your witness statement, you also stated that you can confirm the Tangkulap Forest Reserve is indeed a forest reserve. Can you explain how you made this conclusion?
I received a letter dated 9th of April 2021 from the Sabah Forestry Department that confirmed its status as a forest reserve.
This letter that you mentioned, if I were to show you this letter, will you be able to identify it?
Yes.
Tuan, with the court's permission, we request the letter dated 9th April 2021 from the Sabah Forestry Department, which was addressed to Mr. Ahmad Ladidu, who is the second prosecution's witness.
Yes, you may.
Much obliged, Tuan. Mr. Ahmad, can you see this document? Is it visibly clear to you?
Yes.
Can you confirm that that is your name on this document?
Yes.
Can you please identify this letter?
This letter was sent to me by the Sabah Forestry Department on the 9th of April 2021. It confirms the Tangkulak Forest Reserve as a forest reserve specified under the Forest Constitution of Forest Reserve and Amendment Enactment 1984.
With the court's permission, Tuan, we'd like to put on record that the second prosecution's witness has identified this letter as 9th April, dated 9th April 2021, which he received from the Sabah Forestry Department.
Noted. Thank you.
Much obliged, Tuan. Next, Mr. Ahmad, will you be able to identify the Tangkulak Forest Reserve if I were to show you a site map of the location?
Yes, I'm able to identify it in the map.
Tuan, with the court's permission, the prosecution would like to request the instructing solicitor to display the site map, which was previously tendered by the lead counsel as Exhibit P1.
Yes, you may.
Mr. Ahmad, can you see this document clearly?
Yes.
Can you identify this document, and can you point to us exactly where is the Tangkulak Forest Reserve?
It is a red color part of the map labeled as FMU 17 capital A.
With the court's permission, we'd like to put on record that the second prosecution's witness has identified this site map that was previously tendered as Exhibit P1 as the location map of FMU 17A, B, and C. Additionally, he has also pointed out to the court the specific location of the Tangkulak Forest Reserve.
Yes.
Mr. Ahmad, can you tell us how many trees were cut down and how many logs you discovered?
There were a total of 120 felled trees, which accounted for 201 logs, of which 70 logs are Berlian and the remaining 131 logs are agar wood.
And did you discover anything further from that?
I found out that the 4 general workers at the scene were all employed by Suka-Suka Lok Sdn Bhd for a period of 1 month. Each of the workers had shown their employment letter, which was signed by the human resource manager of the company.
And based on what you just stated, were there only 4 workers?
No, there's one more. I found out that the 5th worker, Mr. Mark Angus, was working as the main person and site supervisor at the scene. He has also been working with Suka-Suka Lok Sdn Bhd for a period of 4 years.
And did you discover anything further from that?
Based on my investigation, I found out that a company known as Suka-Suka Lok Sdn Bhd was awarded with contract worth 1,700,000 to cut down trees at the area gazetted as Forest Reserve, and its chief executive officer is Mr. Alan Kuzuma.
And what did your investigations on Suka-Suka Lok reveal?
I found out that Maju Mega Sdn Bhd is a company based in Kota Kinabalu which awarded the contract to cut down trees to Suka-Suka Lok Sdn Bhd, and the contract specifically provided that all procedures relating to obtaining the permits from the government authorities must be performed by Suka-Suka Lok Sdn Bhd.
Tuan, with that, the second second prosecutor has concluded the examination in chief of Mr. Ahmad Ladidu.
Thank you.
Much obliged.
Objection, Your Honor.
Yes.
Oh, the witness statement presented by the prosecution is not the witness statement that was extended to the defense counsel.
Oh, that was not the witness statement that was extended. Mr.
Yes, Your
Jaya,
Honor.
any reply?
To my knowledge, Tuan, the opposing counsel should have received the witness statement of Mr. Ahmad Ladidu bin Abu Lababu, as we have received their witness statements as well.
Okay.
And the contents of this document is exactly what is written in our own witness statement, which they should have received.
I see. Mr. Aiman, is there any discrepancies of the witness statements and what you have obtained from the prosecution? Any
No, Your
major
Honor.
discrepancies, even if there is any? Even if there is any, is there any major discrepancies?
No, as of the witness statement, there are some speculations added in the presented witness statement currently.
Okay, you can do that during a cross-examination. Yeah,
Thank you.
can
I'm
ask
much
the
obliged,
witness on
Your Honor.
that. Okay, Mr. Jaya,
Yes, Tuan.
do you want to ask the witness to sign the document, the prosecution witness document, witness statement?
Yes, Tuan. With the court's permission, we request the second prosecution's witness, Mr. Ahmad, to sign his witness statement.
Yes, I've signed.
Tuan, with the court's permission, the prosecution would like the letter, which was dated 9th April 2021 from the Sabah Forestry Department, previously tendered as Exhibit P7.
P1?
7.
Is there a P7?
Sorry,
Yeah.
not yet to be tendered yet. There was
You are proposing it to be tendered, right?
Exactly, Tuan.
Okay. Any objection from the defense?
No,
Any objection of
subject
this
to
letter
cross.
to be tendered as exhibit? Through the, I don't see a problem because they are tendering it through the witness, Ahmad Ladidu.
Yes, Tuan.
Any objections, defense?
No objection, Your
No
Tuan.
objection. Interpreter?
Yes.
That's it. Good. We mark this as P7.
Much obliged, Tuan. Tuan, that concludes the examination in chief of Mr. Ahmad Ladidu.
Thank you. We can proceed with the cross.
Your Honor, the defense pray to the court to proceed with the cross-examination.
Let's proceed.
Much obliged, Tuan. Okay. We pray to the court to present ID 5. Photos.
The photograph, right?
Yeah, the photographs taken
Okay.
at the scene.
Yes, please.
Mr. Ahmad Ladidu, do you have any knowledge about ID 5?
Yes.
Do you agree with me that the photographer that took the pictures was Mr. Awang Ahmad Ibrahim?
Yes.
Do you agree that the photos were taken by a camera that is stated in the document?
To be precise, counsel,
Do you agree that the photos admitted in this document were taken by a camera that is stated in the document, which was Nikon D3500 DSLR? Do you agree with me?
yes.
Do you agree with me that the photos were not taken by the UAV?
No, the UAV shows exactly the location with the longitude and latitude which the scene.
Objection. Sorry.
Who's this?
It's Jaya, the second counsel. For
Yes,
the,
Mr. Jaya.
Tuan, apologies. I would like to object to this question and the previous question on the grounds that these are questions that were never asked to the witness during the second examination in chief.
That is okay because cross-examination are not confined to what been asked in the examination in chief. So they are free to ask whatever relevant.
Much obliged, Tuan.
Thank you. Yes, Mr. Aiman.
So I restate my question just now for confirmation. Mr. Ahmad, do you agree with me that the photos admitted by the prosecution was taken by a camera and not by the UAV? Do you agree with me?
It was taken with this Nikon camera, and the UAV shows exactly where is the site is with the exact latitude and longitude.
Mr. Ahmad, since you are not Mr. Awang Ibrahim, the photographer as stated in the document, do you agree with me that you are not able to produce the camera known as Nikon D3500 DSLR. Do you agree with me?
Could you restruct your question, Counsel?
Do you agree with me that you are not able to produce the camera listed in the document, which was Nikon D3500 DSLR? Do you
Yes.
agree with me that you are not able to produce the camera?
Yes.
Do you agree with me that all of the photographs admitted by the prosecution do not show any specific longitude and latitude of the location where the alleged offense took place? Do you agree with me?
Yes, there's no longitude there.
Do you agree with me that the photographs taken are only showing the logs that were already cut off? Do you agree with me?
I do not agree with you.
Do you agree with me that all of these 5 photos did not show Mr. Alan Kusuma or any of his employees were cutting the trees based on the 5 photos? Do you agree with me?
If it is merely based on these 5 photos, yes.
By referring to these 5 photos, do you agree with me that you are not able to identify the species of the trees?
I disagree with you.
Do you agree with me that the photos are not labeled or tagged with any specific information of the species of the trees?
Yes, however, it was tagged after the photo was taken.
It's okay, that's none of my question. Do you agree with me that the photos showed the logs and trees are not labeled? That is the question. Do you agree with me? The logs are not labeled in all these 5 photos?
There are few labeling which is made by the accused, which is Mark Angus and the workers at the scene.
By looking at these 5 photos, do you agree with me that the photos could not confirm whether the logs in the picture were the logs specified in the charge sheet made against the accused? Do you agree with me?
Merely based on these photos.
Yes,
However,
5
right,
photos. These 5 photos. Please stick to these 5 photos. Do you agree with me that these 5 photos could not confirm whether the logs were the logs specified in the charge sheet made against the accused? Do you agree with me? Mr. Ahmad?
the light one is the Belian and the one with the darker color is the agar wood.
Tuan, we pray to the court to present P2, the location map.
Yes, you.
Do you have any knowledge about this map, Mr. Ahmad?
Yes, certainly.
Mr. Ahmad, are you the maker of this map?
I'm not the maker of this map.
Do you agree with me that in the map admitted by the prosecution, there is no longitude and latitude?
However, there is a skill to prove the longitude and latitude, the exact location where the site is located at.
Mr. Ahmad, please stick to my question only. Do you agree with me that the map admitted by the prosecution, there is no longitude and latitude? The map admitted.
Yes.
Do you agree with me that the information illustrated in the map are just the graphic illustration with names? Do you agree with me?
Do not
Agree or not agree? That's all.
not agree.
Could you, sorry. I suggest to you, for geographical accuracy, the longitude and latitude will help to specify the location. Do you agree with me that that particular information is not illustrated in the map admitted by the prosecution? Do you agree with me?
Sorry, could you restruct your question?
For geographical accuracy, do you agree with me that longitude and latitude will help to specify any location relevant to the present case? Do you agree with me?
Yes.
Okay. Do you agree with me that the longitude and latitude is not specifically illustrated in this map? Do you agree with me?
Yes.
Do you agree with me that the Tangkulak Forest Reserve is a huge area as illustrated in the map?
Yes.
Tuan, those are all of the questions for the cross-examination.
Okay, thank you. Re-examination, if any.
It please this court. Tuan, my name is Jaya, and I appear before this court to conduct the re-examination of the second prosecution witness, who is Mr. Ahmad Adidu. With the court's permission, the prosecution would like the both photos that were presented to the witness to be shown on the screen.
Yes, you may.
Much obliged, Tuan. Instructing solicitor, can you please display the pictures?
With the court permission, I would like to display my pieces of photo by sharing the screen.
Thank you. Mr. Ahmad, can you tell us who is the person who took these pictures?
Awang Ahmad Awang Ibrahim.
And who instructed Awang Ahmad to take these pictures?
Mr. Richard Lee.
And what is the specific camera that he used?
Nikon D3500 DSLR.
Mr. Ahmad, are these pictures referring to the Tangkulak Forest Reserve?
Yes.
Mr. Ahmad, what do these pictures show that you can see right now? What are all of these things?
The items being seized at the scene.
Can you tell us the items that were seized at the scene?
Sorry, counsel, could you rephrase your question?
Sure, certainly. Can you please tell us all of the items that were seized at the scene, which you can see in this picture?
Objection, Your Honor. Objection, Tuan. The question is not raised during cross-examination.
Okay, they have not raised it in the cross-examination. But any event, what you have actually inquired is stated facts in the examination chief and evidence. Is that there isn't need to peruse that evidence, that form of evidence again.
Certainly. Much obliged, sir.
Unless you have other questions, you may proceed. Yeah.
Thank you. Much obliged, sir. Mr. Ahmad, instructing solicitor, can you please show the pictures that show the marks on the logs? Yes, this one. Thank you. Mr. Ahmad, can you identify this picture? What do you see from this picture?
There are some marks on the logs itself.
Can you tell us what these marks mean? Can you also explain what the different logs are?
The light one is the Belian and the dark one is the Agar wood. However, these marks are marked by the Mark Angus and his 4 workers at the scene itself.
Much obliged. With the court's permission, the prosecution requests the map of FMU 17A, B, and C to be displayed to the witness.
Yes.
Mr. Ahmad, can you see this document clearly? Is it clear to you visibly?
Yes.
Mr. Ahmad, can you tell us how you came to be in possession of this map?
All right. At first, I was given an exact longitude and latitude by Peter Mongi.
Apologies, Mr. Ahmad. My question to you was, how did you get this map? Who gave you this map?
From Mr. Richard Lee.
And do you know how Mr. Richard Lee acquired this map?
Objection, Your Honor.
Yeah.
The questions are not raised during cross-examination.
So Jaya, apparently the question was not raised unless you have a specific question that was touched
Yes.
on by Mr. Aiman.
Yes,
You
Tuan.
can inform us.
The specific question that Mr. Aiman asked was, he asked Mr. Ahmad Ladidu whether he's the maker of the map or not. And Mr. Ahmad Ladidu stated that he's not the maker of the map. Okay. And I'm now asking the question of how Mr. Richard Lee acquired this map to prove to the court the maker of the map, the identity of the maker of the map.
Yeah, I think it's relevant, Mr. Aiman. The question is based on what you have asked. Yeah, they're just exploring on the other side of the truth, how he acquired the map. I think it's a fair question. Yeah, you're allowed, Mr. Jaya.
Much obliged, Tuan. Mr. Ahmad, can you please answer the question? For clarity's sake, I'll repeat the question. Can you please tell us how Mr. Richard Lee acquired this map? Who gave Mr. Richard Lee?
Mr. Richard Lee had consulted the expert from the Sabah Forestry Department and produced the map with such, and he had provided them with the image that had captured with the UAV clearly with the latitude and longitude there. And he also provided the measurement of the crime scene that he recorded during the seizure. And by matching the image captured by the UAV and the measurement that he got during the seizure, he came out with a blue spot, which we can see from the map here, to point out the exact location with the exact measurement for the area of the illegal logging.
Thank you, Mr. Ahmad. Your Honor, that concludes the re-examination of Mr. Ahmad Ladidu bin Abdullah Babu.
Thank you.
Much obliged, Tuan.
Any further requests? Can we discharge the witness?
With the court's permission, the second prosecutor requests the second witness to be dismissed.
Thank you, Mr. Ahmad Ladidu. Mr. Ahmad Ladidu is also the IO of the case, right?
That's right, Mr. Tuan.
Thank you. Thank you. Now, with the does the prosecution have any other witnesses to call?
No, Tuan. That is all.
Can we proceed with submission?
Certainly, Tuan.
Yes. Then I call upon submission to be made by the defense, followed by the prosecution. Mr. Daniel, do you mind to submit on this at the end of prosecution's case?
Yes, Tuan.
Yes,
Tuan.
you may.
Tuan, may the defense counsel proceed with the opening statement?
Yes. You can actually not if you are not calling it defense at the moment, we want you to submit. Is there any submission that you wish to make?
Oh,
at the end of prosecutions?
At the present time being, no.
Before I make my decisions?
No, Tuan. We will only
no submission at the end of prosecution. Mr. Jaya, does the prosecution have any brief submissions to make?
No, Tuan. For the purpose of this competition, it is assumed that a prima facie case has
Yeah, that will be decided by me. Yeah.
No submission.
Is there any submissions to be made?
Only a closing submission at the end of the trial.
Okay, right.
Much obliged, Tuan.
Ladies and gentlemen, on hearing the submissions, evidence presented, although there is no submissions made for the purpose of these competitions, but for the purpose of an accurate proceedings, a submission will be enhanced by both parties before the court finds whether a prima facie case has been proven or not. But the purpose of this competition, we are dispensing with the submissions. Okay, let it be placed on record. Ladies and gentlemen, be that may, upon hearing and taking into considerations the relevant evidences that have been put forward by the prosecutions and being cross-examined by the defense before this court, and I'm appraised by the facts surrounding the charge against the accused person, and this court herein are guided by the tried principles laid down in public prosecutor against Lui Kao Chai and public prosecutor against Bala Chandran's, both decision of the federal court, where these court are obliged to follow, and the relevant provisions in the forest enactments, the finding of this court is the prosecution have proven a prima facie case, and herein I call upon the accused to enter on his defense. Thank you. You may, the defense, you might want to inform the court on the route that you wish to take in your defense.
Tuan, may the defense counsel proceed with the opening statement?
Yeah, before I proceed with the defense, perhaps we could allow about, what is the time now? Interpreter, where is the interpreter? Mr. Adam,
Yes, Tuan.
what is the exact time now?
Right now is 10:54 a.m. Tuan.
We are still within the time. Yeah, 10:54. Good observation by all parties in observing the time allotted to you. Congratulations for that. So we could take, we could stand down the matter for about 10 minutes or so before we resume for the case of defense. Thank you. We will join back. Yeah, so in 10 minutes. Yeah, Mr. Adam, please alert me when the 10 minutes time limit expires, so I could rejoin.
Will do, Tuan.
Okay, and allowing also to defense to prepare their cases. Thank you so much.
Much obliged, Tuan.
Much obliged, Tuan.
Thank you. We just stop the video and dismiss.
Apologies. Tuan Salim, are you there?
Yes, Adam. Yes.
Yes, Tuan. The 10
10
minutes.
minutes time expired.
Yes, Tuan.
Okay, I think should be okay. So we'll come in maybe in a 1 minute time or something. And everybody is here, please let me know.
Will do, Tuan. Is everybody here? The Defense Counsel,
Yes.
the prosecution.
Yes, we are all present.
Right.
Okay, I think we can proceed with the defense. May I call upon defense to present their case?
Yes, Tuan. Tuan, may the defense proceed with the submission?
Defense, you want to proceed with what?
The opening statement.
Opening statement. Okay. Yes, yes, Daniel, proceed.
Much obliged, Tuan. Tuan, the responsibility to prove the case in hope of a prima facie lies within the responsibility of the prosecution. When the prima facie has been established, it is the utmost duty of the defense counsels to cast reasonable doubt. Tuan, the prosecution team in this particular case has failed to fulfill the ingredients under section 20, subsection 2 of the Forest Enactment 1968. The failure includes, number one, the failure to prove that the accused has no express authority. Number two, the failure to prove that the act of cutting trees was done by our client. Number three, the failure to prove—
When you say that no express authority, what do you mean by that, Mr. Daniel?
no legitimate license, Tuan.
Okay, right. Not no express authority to prosecute.
Mm.
All right. They have all those. They have the prosecution right. Okay, under section 377. So I just want to clarify that. Okay, yeah, proceed.
Number three, the failure to, much obliged, Tuan. Number three, the failure to prove that the trees that were allegedly cut and fell was on the forest reserve area. And number four, the failure to prove that the act by the accused is done in furtherance of common intention under section 34 of the Penal Code.
Okay.
The defense counsel would like to deliberate more on the arguments and contentions based on the oral testimonies conducted throughout this particular trial. Tuan, the defense counsel will call upon two witnesses. Number one, Mr.
Mr. Daniel, before we move on, have you also taken into account section 32 of the Forest Enactments?
Section, apologies, Tuan, can you refer?
Section 32 of the Forest Enactment. Are you aware of that?
Section 32 of the Forest Enactment?
Yes.
Yes.
No.
Yes.
You don't need to
Yes.
refer. I mean, are you aware of that?
Yes, apologies.
Okay. All right. Okay. Proceed.
Much obliged, Tuan. Tuan, the defense will call on two witnesses. The first is Mr. Alan Kusuma, who is the accused, and second is Mr. Iwan Juslin, the operations manager of Suka Suka Lodge in Bahad.
Okay.
Tuan, the defense would like to scrutinize
For the purpose of this competition, is this witnesses are being readied or asked or commanded by the organizer, or is a choice of the parties?
commanded by the organizer, Tuan.
Commanded by the organizer means what? They choose the witness for you.
Yes.
You have no liberty to choose. Jaya, is that true?
Apologies, Tuan. I'm not sure I understand the question.
Yeah, there's witnesses and all that. Are you all being asked to choose these people to be these particular people to become the witness, or you all have the liberty to choose whoever you all want and to play whatever role?
We can only bring to the court the witnesses that the competition states, which means for prosecution, we're only allowed to bring in Mr. Richard Lee and Mr. Ahmad Ladidu. And for defense, the only two witnesses that are allowed to be brought in is firstly Mr. Alan Kusuma and secondly Mr. Yuan Juslin. And we cannot deviate from that whatsoever.
I see. Okay, I got it. Thank you.
May we proceed with the opening statement, Tuan?
Sure, sure. I thought you already finished, Mr. Daniel.
Tuan, the prosecution has insufficient evidence, which includes, number one, there is insufficient evidence to prove that the permit was allegedly fake. Number two, there are inconsistencies between the police report and the notice of seizure. Number three, the map did not state the latitude and longitude of the alleged crime scene, which leads to inconclusive evidence. And number four, the defense counsels would like to submit and show to the court that there is a break of chain in custody of the evidence in respect of the control, marking, and labeling of items of the evidence seized by the Forest Department. Mr. Tuan, in conclusion, the accused indeed have obtained the permit legally with due diligence and good faith and in pursuant to the Forest Enactment 1968. In addition, the Act of the Sabah Forestry Department issuing the permit and was further verified by their own Telupit forestry officer supplemented the argument that the accused is not guilty for the offense under the Forest Enactment 1968. After hearing all the contentions and arguments, and after scrutinizing all the evidences by the prosecution team, we humbly pray for the verdict to be returned in favor of our client, Mr. Alan Kusuma. That is all the opening statement from the defense counsel. Tuan?
Okay, proceed with your witnesses, if you have any.
Tuan, the defense counsel would like to call upon the first witness, Mr. Alan Kusuma, who is the accused. Much obliged, Tuan.
Thank you. How are you going to give evidence?
Tuan, we would like to present the witness statement.
Witness statement.
The defense would like to display the witness statement by Alan Kusuma.
Mr. Kusuma, can you please give your oath?
I, Alan Kusuma, with PC number 701257553, take oath and declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Okay. Mr. or Miss Allen? Mr. Allen.
Mr. Allen,
Yes, proceed. Yes.
Tuan, may the defense counsel proceed with the examinations in chief?
Yeah, please, please.
Much obliged, Tuan. Mr. Allen, I refer you to the witness statement that is submitted by you. Is this the witness statement submitted by you?
Yes.
Tuan, since the witness has the knowledge and is able to identify his witness statement, we pray that this document will be marked and exhibited to the court.
Yes, but you have to read the statement first before I be marked.
The witness, pray for the witness statement of Mr. Alan Kusuma to be marked and exhibited to the court.
Yeah, we will mark it at the end of the evidence. Okay, go through the witness statement first.
Okay, much obliged, Tuan. Mr. Kusuma, based on number 1 of your witness statement, you stated that you are the Chief Operating Officer of Suka-Suka Lodge Sdn Bhd. Mr. Kusuma, what does your
But
responsibility?
Mr. Daniel, I was told by Miss Lim is it, earlier that the organizers do not allow the witness statement to be marked. Is that so? Can you clarify on that?
Apologies. I think the defense counsels would like to proceed with not tendering evidence, a witness statement as the evidence.
Not tendering.
For the purpose of this competition, we will.
For the purpose of this competition.
Yeah.
I mean, they'll be asked not to tender, is it? I mean, that is an accurate thing, lah.
Yes.
That is what being told by the organizer.
Yes.
Okay.
Apologies, Tuan.
No worries.
There has
No
been
worries.
a misunderstanding between.
Fair enough. Fair enough. No worries. Proceed.
The defense would like to proceed the examination in chief. Yeah. Mr. Kusuma, can you briefly introduce yourself to the court?
Yes. My name is Alan Kusuma, 51 years of age. I am the Chief Operating Officer at Suka-Suka Lodge Sdn Bhd that is situated at level 3AA Menara MAA at Kota Kinabalu.
Mr. Kusuma, what does Suka-Suka Lodge Sdn Bhd do?
Suka-Suka Lodge Sdn Bhd mainly doing the activities of logging.
Mr. Kusuma, how long have you been the position of Chief Operating Officer of the company?
It has been 5 years.
Mr. Kusuma, may I ask, how long have you been in the logging industry?
For more than 5 years.
Mr. Kusuma, why are you here in this honorable court today?
I came before the court today to testify on the alleged crime against me, which I was being charged for cutting the trees in Tangkulak Forest Reserve in the district of Teluk Sabah without license or expressly authorized by the Sabah Forestry Department under Section 20, Clause 2 of Subsection 2 of the Forest Enactment 1968.
Mr. Kusuma, for clarity, apologies, where did the company conduct the logging activity?
At Tangkulak Forest Reserve.
Mr. Kusuma, what do you know about the Tangkulak Forest Reserve?
I know that Tangkulak Forest Reserve is a reserve area in which I need to obtain a proper approval before commencing any activities in this area.
Mr. Kusuma, why did the company conduct the logging activity in the first place?
Your Honor, the prosecution would like to raise an objection against the defense because they are deviating from their witness statement displayed on the screen.
Okay, what is the objections?
My objection is they are deviating from the screen.
Deviating?
Yes.
Oh, they're adding in further. That is allowed. That is allowed. You know, they can actually step out of whatever being prepared there. You know, because it's an oral proceeding, although it's been taken as a witness statement, but it is an oral proceedings. So they can actually add in or even make an amendments. Okay, do not wait at the end of the whole thing for them to make any amendments. If there is any additions to what being stated here, they can do so. But Mr. Daniel, just a reminder, as far as possible, stick to whatever being written there in the witness statements. Okay, hold it strictly. If you have any extra questions that you wish to raise and put it to the witnesses, okay, you can raise it at the end of the questions. All right. So that would not confuse the parties. Okay, thank you. Thank you.
Mr. Kusuma, why did you conduct the logging activity in the first place?
Contract worth RM 1.7 million ringgit by Maju Muga in order to do the forest clearing at this area.
Mr. Kusuma, When did the company sign the contract?
March 2021.
Mr. Kusuma, why did you conduct the logging activity in the first place, knowing the fact that it's a forest reserve?
See, we are commencing the logging activities as I was assured by Dato' Ahmad Zamani, the CEO of Maju Megah Sdn Bhd, that special permission has been given for them to develop the chalets there.
Mr. Kusuma, for clarification purposes, who is Dato' Ahmad Zamani?
It's the CEO of Maju Megah Sdn Bhd.
Mr. Kusuma, based on the contract, what is the obligation of Suka-Suka Lot Sdn Bhd?
To be specific, our responsibilities based on the contract are: the first one is to do the forest clearing at Tangkulak Forest Reserve area, and secondly, to obtain proper permit from the government.
Mr. Kusuma, what are the logging activities specifically?
The logging activities are to fell off the identified trees, to shear all the tree limbs, to cut them into the desired lengths, and then we will be transporting them into the company's sawmill.
Mr. Kusuma, what are the duties of Maju Megah Sdn Bhd in this specific contract?
Well, duty to conduct EIA lies with Maju Megah Sdn Bhd, as they are the company that will develop the exclusive chalet.
Next question, Mr. Kusuma, what happened after the signing of the contract?
After the signing of the contract, I obtained the permit from Datuk Kong Kalingkong to enable my company to do the forest clearing at this area, as it is our responsibility.
Mr. Kusuma, how did you obtain the permit?
Through Datuk Kong Kalingkong, the chairman of Kinabalu Lumba Berhad.
Mr. Kusuma, why did you obtain the permit through Datuk Kong Kalingkong?
I obtained the permit from him through his good assistance, and because he is a much more experienced person in the logging activities.
Mr. Kusuma, what is the relationship between you and Datuk Kong Kalingkong?
Well, he is a good friend of mine since primary school.
Mr. Kusuma, what did you do after you have obtained the permit?
So after I obtained the permit, I asked my operation manager, Mr. Iwan Juslin, to verify the permit with the Telukut forestry officer immediately after obtaining the permit from Datuk Kong Kalingkong, despite the assurance given by him.
Mr. Kusuma, what orders did you give? The specific orders that you give to Mr. Iwan Juslin?
Specifically ordered Mr. Iwan to verify the permit to determine its legitimacy.
Mr. Kusuma, why did you give the orders in the first place?
Because we wanted to legally pursue the logging activity in the Tangkulak Forest Reserve area.
Mr. Kusuma, what happened after you gave the orders?
Well, Mr. Iwan reported to me a few days later that he had met in person with the Telukut District Forestry Officer on 17 March, and then at his office. So my operation manager told that our application was made and has been approved on 15 March 2021.
Mr. Kusuma, what is the proof of the approval?
Mr. Iwan Juslin noted that the approval for Suka-Suka Lot Sdn Bhd was already entered in the register of approved permit.
Mr. Kusuma, for clarification purposes, apologies, who is Mr. Bonaventure Sipaun?
He is the Telukut District Forestry Officer.
Mr. Kusuma, what did the company do after receiving the approval on 15th of March 2021?
After receiving the approval, we'll commence with the logging activity.
Instructing solicitor, I think you're not actually scrolling according to the evidence being forwarded here. You need to keep tab with the questions and the answers.
Apologies, Tuan, but the questions addressed was an additional questions.
or additional.
we only
Daniel,
have-
is that
Yes.
true?
Yes, Tuan. It's an additional.
That's what I'm saying. You know, your as far as possible, try to stick to the witness statement. Maybe at the end of the witness statement, perhaps you can actually put in all the other additional questions at your liberty. Okay. Because I'm sure that parties, prosecution and the parties here do not know the kind of questions that you are posing here. If you depart so much from what being written in the witness statement. Okay. But yeah, that is only a suggestion. But if you feel so, what you can do is indicate to the court that this is an additional questions.
Apologies, Tuan.
Yeah. Okay. Thank you.
Tuan, the defense counsels have finished with the examination questions, but may we proceed with additional questions?
Yes, please, please.
The defense counsel would like to request to show the document of Borang 2A that is exhibited as ID3. Mr. Kusuma, I refer you to this bundle of the document presented by the prosecution. Mr. Kusuma, why did you give the photocopied permit to the site supervisor?
Well, it has always been the policy of our company to give the photocopy permit to the site supervisor.
Mr. Kusuma, why is your name stated in the document?
Because the application was made by Dr. Kong Palekong and I have no further knowledge regarding the application made.
Mr. Kusuma, what are the logging activities allowed under the permit?
To extract the forest produce and also to do the logging activities there.
Mr. Kusuma, who was at the Tangkulak Forest Reserve during the logging activity?
There were 5 persons in total, which is my site supervisor, Mr. Mark Angus, and 4 other general workers.
Mr. Kusuma, why are the state authorities at the location?
They were doing their daily supervision and patrolling around the area.
Tuan, that is all the questions for the examinations in chief.
I see.
Therefore,
Okay. Thank you. Cross, if any.
Tuan, the prosecution shall now commence cross-examination against DW1, Mr.
Yes.
Alan Kusuma.
Yes, you may.
Mr. Alan Kusuma, are you the CEO of Suka Lok, Sanjang Berhad?
I am the Chief Operating Officer, the CEO of Skeletal.
Is Suka Lok a company involving in logging activities?
Yes, we are a company involving in logging activities.
Have you obtained a contract with Maju Megah?
Yes, we do obtain the contract with Maju Megah and was signed on the 3rd March 2021.
Your contractual obligation under the contract with Maju Megah is to fell trees within the area stated in the contract. Am I right?
Yes.
Can we refer to your defendant witness 1 witness statement served to the prosecution? If our instructing solicitor can help display much apologies. Can our instructing solicitor display the defendant witness statement?
With the court permission, I would like to display the witness statement stated given in the defense.
Okay.
Period.
Mr. Alan Kusuma, can you look at paragraph number 4?
Yes.
Yes, can you please read out on line 2, starting from I know?
I know that the site is within Tangkulak Forest Reserve, but I was assured by the CEO of Majumuga Simberhai.
Thank you, that's all, thank you. So I put it to you that the contractual obligation of Suka-Suka Lok under the contract with Majumuga is to fell trees within the Tangkulak Forest Reserve. Am I correct?
Yes.
Yes. So the contract between Suka-Suka Lok and Majumuga was signed on 3rd March 2021.
Yes.
So after the trees were fallen, the logs will be used to construct the chalet. Am I correct?
Yes.
And in order to fulfill this contractual obligation, Suka-Suka Lok needs to fell the trees.
Yes.
And the site supervisor and 4 general workers were conducting forest clearing activities between 3rd April to 5th April. Am I correct?
Apologies, can you repeat the question?
Certainly. Your site supervisor and were conducting forest clearing activities in Tangkulak Forest Reserve between 3rd April to 5th April. Am I correct?
Yes.
Yes. And you have also another 4 general workers logging trees within the Tangkulak Forest Reserve on 3rd April to 5th April.
Yes.
Yes. So the 120 trees felled were actually fallen by Mark Angus and also the 4 general workers. Am I correct?
I couldn't verify on that as I am not at the scene on that moment.
Pardon, can you please repeat your answer?
I couldn't verify on the number of the felled trees because I am not present during the operation.
But they were complying to your instruction to fell the trees in Tangkulak Forest Reserve. Am I correct?
Yes.
Yes. So moving on, you were not at the crime scene when Mark Angus and the 4 general workers were arrested.
Yes, I am not there.
Only the site supervisor were at the crime scene.
The site supervisor and 4 general workers, yeah.
There are also another 4 general workers at the crime scene.
Mm-hmm.
Yes.
Yes.
So is the site supervisor Mark Angus?
What's the question again?
Is the site supervisor Mark Angus?
Yes.
If I may refer you to your witness statement, defendant's witness statement found in paragraph 3.
Mm-hmm.
Instructing solicitor, please display the defendant's witness statement. So can you please read out the first 2 sentences of paragraph 3?
On the morning of 5th April 2021, my workers were stopped from their work by the Telpik forestry officers at Tangkulak Forest Reserve area. Do you want me to continue?
Yes, another sentence, please.
The site supervisor, Mr. Mark Angus, was asked by the Telpik forestry officers to furnish the work permit for such activities.
Yes, thank you. So when you mentioned my workers, you were referring to the site supervisor, am I correct?
Yes.
So the site supervisor is actually an employee of Suka-Suka Lok Sanjan Berhad. Am I correct?
Yes.
And Mark Angus worked under your instruction. Am I correct?
Yes.
And pursuant to your instruction, he felled trees within the Tangkulak Forest Reserve.
Yes.
So have you obtained a forest permit?
In relation, can you restart the question again?
Yes, certainly. Have you obtained a forest permit for the purpose of the contract between Suka-Suka Lok Sanjan Berhad and Majumuga Sanjan Berhad?
Yes, we do obtain the permit from the Tukang Kalkong.
So you are actually aware that in order to do forest clearing within the forest reserve area, you need a forest permit.
Yes.
So do you agree with me that if you didn't obtain the permit, you would not commit illegal logging?
Yes.
It is unlawful to clear a forest without a forest permit.
Can you repeat the question?
So it is illegal for you to clear the forest if you do not have a valid permit.
Yes.
Yes. With the permission from the court, I would like to refer the witness to the allegedly fake permit, the Form 11A, lesson mengambil keluaran hutan bebas dari royalty dated 10
Yes,
March
ma'am.
2021.
Yes.
At the same time, with the permission of the court, I would also like to refer the witness to the statutory Form 11A under the Forest Rules 1969.
Yes, you may.
And for both forms to place side by side.
Yes.
Instructing solicitor, can you please display?
I'd like to display the exhibit by sharing the screen.
Witness, can you see both licenses on the screen?
Yes, I could see.
Yes. Looking at the license on the left side, at the title there, it states Borang 11A, lesson mengambil keluaran hutan bebas dari royalty. Am I correct?
Can you please
Object.
zoom?
Object. Objections, Tuan.
Hello? Yes?
Objections, Tuan.
Yes, yes, Daniel.
The prosecution has tendered new evidence.
Your Honor.
Mm-hmm.
Tuan, in response to the defense objection, the prosecution submits that the Form 11A displayed on the right side is not an additional evidence. It is an authority under the Forest Rules 1969.
Okay.
And the purpose of doing so is to show the discrepancies between statutory Form 11A and also the license obtained by the accused Alan Kusuma.
Yeah, what you're trying to do is trying to compare with the original one and also the fake. Is that
Yes.
you alleged that being faked? You should have tendered it through the investigating officer, isn't it? Or at least forwarded that piece of document under 51A. You see, for purpose of clarification, which one is the authentic document and which one is the fake, right, Ms. Lim? You should have done that through the IO. You see,
Tuan, the Form 11A showed on the right side is not an additional evidence. It is only a legal authority under the forest rules. Hence, the prosecution submits that this authority need not be included in the pre-trial bundle of documents.
That's true, but you have not acceded this document to them by way of 51A, right?
Yes.
Right. So unfortunate, that we are bound by the law. That 51A compliance, unless you don't have the document at that material time when you forwarded the other documents to the defense, this document are not made available, then yes, we can actually use the exclusion clause under 51A. But unfortunate, I am bound by the 51A law, and therefore I don't allow Forest Rule Form 11A, Forest Rule 1969 that you intend to tender at this juncture. Yeah. So you can only refer to the one that they already have it earlier, okay, which you have alleged to be fake. Thank you.
Much obliged, Tuan. Instructing solicitor, please remove the Forest Rules 1969, and can you please, with the permission from the court, the prosecution would like our instructing solicitor to compare the Borang 11A and also the letter obtained from the Jabatan Perhutanan Sabah addressed to Mr. Ahmad Ladidu, which was previously tendered as P7, the letter.
Lim, okay, though I made a ruling that to be not to be tendered as a P exhibits, okay, it doesn't stop you from referring that piece of documents, okay? You can always refer to the witnesses, okay, but you just cannot tender. Even if you wish to tender, there will be only an ID, okay? Right.
Much obliged, Tuan. Instructing solicitor, with the permission of the court, we would like to refer the witness to both the Form 11A and also the statutory forms of Forest Rules 1969.
Tuan,
Yes. Yes,
um,
Daniel.
objections due to the
Yes.
fact that the organizers,
Mhm.
as far as the defense counsel is concerned,
Mhm.
that the organizers does not allow to adduce new evidence during the day of the trial.
Don't allow the new evidence during the trial.
Yes.
When you say evidence, you're talking about what? Documentary evidence. Alim, can you clarify that position by an objection by Daniel?
Tuan, the Form 11A that the prosecution is referring to is not a new evidence. It is merely a law and authority under the Forest Rules 1969. And
Right. Daniel, do you have any reply to what Ms. Lim said?
Tuan, if it's not a documentary evidence, then the prosecution team should not bring forward the form. It should only showcase the law or the authority itself, not the specific form. That leads to a documentary evidence, Tuan, in the
Yeah.
defense arguments.
But Daniel, I have written a position that, I'm not going to allow this or a part of this piece of document to be admitted as an evidence. It's just for the purpose of referrals to the witnesses. Yeah. So I think we can take that position since the prosecution did not comply with 51E. Yeah.
Much obliged, Tuan.
Okay. Thank you. Yes, Ms. Lim, you can proceed.
much obliged, Tuan. Mr. Alan Kusuma. Mr. Alan
Yes.
Kusuma, can you
Yes.
confirm that on the left side, the Form 11A, on line number 2, lesson ini membenarkan Alan Kusuma, number KB, and stated the IC number. Can you confirm that that is your name?
Yes, it is my name and my IC.
Thank you. And on line 3, it states your address. Is that your address?
That is the company's address, Suku School Lot Number address.
Referring to the permit on the right side. So do you agree with me that this is a Form 11A with the same title stating license to take lesson mengambil keluaran hutan bebas dari royalty? Do you agree with me? Witness, Mr. Alan Kusuma, do you agree with me that this is a Form 11A, license mengambil keluaran hutan bebas dari royalty?
Yes, I agree.
Yes. If we look at the line number 4 on the left side, which is your allegedly fake permit, it states that untuk memotong, mengambil dan memindah keluar, untuk memindah keluaran hutan simpan tengkulak, kawasan. Is that correct?
Counsel, the application was made by Dr. Pangkalikong.
I do understand. Can you please answer my question with a yes or no? Is
Yes,
it stated?
just answer. Later they can do. Your defense counsel can verify during re-examination. Just answer the question.
So what's the question again?
The question is it stated that untuk memotong, mengambil dan memindah keluaran hutan simpan tengkulak, kawasan?
Yes.
Yes. If we look at our right side, if we ignore the English version, we just refer to the BM version at line number 4. Does it state that untuk memotong, mengambil dan memindah keluaran hutan?
Yes.
Yes. Referring you to line number 5. Okay, on the right side,
Which one?
on the left side, do you see seperti yang diperilhalkan berikut?
Yes.
Yes. So on the right side, do you see seperti yang diperilhalkan berikut?
Yes.
Yes. Do you see a blank space following the word berikut on the right side of the permit? A
Yes.
line, dotted lines. Yes.
Yes.
Referring you to the line number 4 in Form 11A on the right side. Following the
Okay.
word keluaran hutan, do you see any dotted lines?
No.
No. If you refer to your permit, why is there a, do you agree with me that there is a dotted line adding the words simpan tangkulak, kawasan?
There is a dotted line.
And is there a description of simpan tangkulak, kawasan?
Yes.
Yes. Instructing solicitor, you may take down the Form 11A of Forest Rules 1969. And with the permission of the court, I would like to refer DW1 to the letter obtained from Jabatan Perhutanan Sabah. Yes. Witness, do you see the letter on the right side?
Yes.
Yes. If you look at the top of the letter, does it state Jabatan Perhutanan Sabah, Sandakan Sabah?
Yes.
Yes. So on the title of the letter, immediately after Tuan, it states pengesahan status hutan simpan tangkulak.
Yes.
Yes. If you refer to paragraph 2, the kawasan states hutan simpan tangkulak. Am I correct?
Yes.
And the kawasan states 27,258 hectares. Do you agree with me?
Yes.
Yes. So referring to your allegedly fake permit on the left side, following after seperti yang diperilhalkan berikut. If we refer to keluasan, it states 1,300 km persegi. Am I correct?
Yes.
Yes. So if we, are you aware that if we convert 27,258 hectares into kilometer persegi, it is only 270 kilometer persegi. Are you aware of that?
I'm aware of that.
Yes. So do you agree with me that 1,300 kilometers persegi and also 270 kilometer persegi are huge differences?
Yes.
Yes. So do you agree with me that the permit that you have obtained, which states the 1,300 kilometer persegi, has exceeded the area of Tangkulak Forest Reserve?
Yes.
Yes. Instructing solicitor, you may take down the letter on pengesahan status hutan simpan Tangkulak and refer us to Form 11A will be sufficient. Witness, do you see the authorized signatory of this Borang 11A?
Yes.
Yes. Is the authorized signatory, can you scroll a little bit down so we can show the witness on the part of signature? Do you agree with me that the person stated on the permit is Eunice Marlis?
Yes.
Yes. So when you instructed Yvonne Giselin to contact Mr. Bonaventure Sipawun, is that correct?
Yes.
Yes. Do you see the name of Bonaventure Sipawun on this permit?
No.
Do you make any attempt to contact or make an appointment with Miss Eunice Marlis?
As mentioned before, the application was made through the good
Witness?
assistance of Dato' Kong Kalinkong.
No,
Please
Puan Khairi, also on what do you call that, Miss the accused person, and Alan Kusuma, only answer the question. Okay, there is a need for you to explain. The question was a suggestion, so you just have to answer the question, yes or no. Okay, thank you.
Much obliged. Thank you.
Witness, did you make any attempt to make an appointment with Eunice Marlis?
No.
Just now, during your examination in chief, you have also indicated that you received the news that the permit was approved on 15 March 2021. Am I correct?
Yes.
So as we refer to the permit that you have obtained, it states that tarikh is 10 March 2021. Am I correct?
Yes.
I put it to you that the wrong date was inserted in the permit. Yes or no? Yes or no? Witness?
No.
No. I put it to you that the permit that you obtained is a fake permit. Do you agree with me?
The question is the permit that I obtained is fake.
Witness, you don't have to explain to me. You only need to answer me yes or no.
Can you rephrase the question?
I put it to you that the permit you have obtained is a fake permit. Do you agree with me?
No.
You have instructed Yvonne Jocelyn to to verify the permit with Mr. Bonaventure Sipaun. Am I correct?
Yes.
You stated that the purpose to verify the permit is to determine the legitimacy of the permit. Am I correct?
Yes.
And you received the permit on 16 March 2021. Am I correct?
Yes.
And the day you instructed Yvonne Jocelyn to verify the permit is on 17 March 2021.
Yes.
Yes. That is one day after you received the permit. Am I correct?
Yes.
Yes. Do you agree with me that the purpose to verify the permit is to remove any likelihood of fakeness or forgery, however slight it is?
Yes.
I put it to you that you suspected the permit was fake when you received the permit on 16 March 2021. Do you agree with me?
No, I didn't suspect anything.
I put it to you that because you suspected the permits were fake, you instructed Mr. Yvonne Jocelyn to verify the permit with Mr. Bonaventure. Do you agree with me?
No.
This ends the prosecution's cross-examination against DW1.
Okay.
Much
Thank
obliged.
you. Any re-examinations?
May the defense counsel proceed with the re-examination?
Yes, please.
Mr. Alan Kusuma, when was the offense committed?
On the 5th of April 2021.
One, the
Yes.
prosecution has an objection against the defendant's question on the ground that when the offense was committed was not addressed during cross-examination.
Mr. Daniel, the question apparently was not put during cross-examinations, unless you can highlight which part of the questions that Ms. Lim's question that you wish to clarify.
Tuan, the question posed by the prosecution team is on when they established the fact that.
Yeah, which can you highlight exact questions that Ms. Lim posed that you wish to clarify?
The second question, which
what is that? At verbatim, can you highlight it to us?
What happened between the 3rd and 5th of April 2021, Tuan?
Okay, so what question that you wish to clarify?
I would like to question on the question of when did the offense committed, just to clarify on that question.
I think we can allow that, Ms. Lim. Yeah. Okay. Thank you. Yes, Daniel. You proceed.
Much obliged, Tuan. Mr. Kusuma, when was the offense committed?
On 5 April 2021.
Mr. Kusuma, for clarification purposes, what was your role in Suka-Suka Lot Sdn Bhd as its Chief Operating Officer?
My roles as Skeletal is as the Chief Operating Officer.
Mr. Kusuma, what was your role in obtaining the permit?
I obtained the permit because it was our responsibilities through the contract between Suka-Suka Lot Sdn Bhd and Maju Megah.
what orders that you, who is the person that you delegated to obtain the permit?
My operation manager, Mr. Iwan Jusli.
Mr. Kusuma, can you explain who verified the permit?
The Telpit District Forestry Officer, Mr. Bonaventure Sipaun.
For clarification purposes, who is Mr. Bonaventure Sipaun?
Apologies. He is the District Forestry Officer.
Mr. Kusuma, can you explain to the court why Mr. Bonaventure's name is not stated in the permit?
Is that question being placed by Ms. Lim?
Yes, when Ms. Tim posed the question on Mr. Bonaventure's presence.
Can you repeat the question?
Mr. Kusuma, can you explain why Mr. Bonaventure's name is not stated in the permit?
Because the one who applied the application was Datuk Kong Kalikong, and I have no further knowledge regarding the permit.
Mr. Kusuma, what happened to Mr. Bonaventure Sipaun, the Telupit district officer?
He died on 28 March 2021.
Your Honor, Tuan,
Yes,
apologies, Tuan.
yes.
The previous question on the whereabouts of Bonaventure Sipaun was not mentioned during cross-examination.
Okay. Daniel, I don't think so. Ms. Lim have raised the issue on that. Perhaps, you may, unless you want to rephrase it in some other way that is relevant to what being asked in cross-examination, or else you can drop it.
Tuan, the defense counsel would like to rephrase the question.
Okay, what is it?
Mr. Alan Kusuma, what happened to the officer that has verified the permit?
The officer died before, the officer died on March 2021.
Which officer are we referring to? Is it Eunice or is it Bonaventure?
Bonaventure Sipaun, Tuan.
Bonaventure Spawn. Okay.
Tuan, that is all the examinations. That is all the questions for the re-examination.
Okay.
We pray to the court for the witness, Mr. Alan Kusuma, to be released.
Yes. Mr. Alan Kusuma, you're not going to be released. At the moment, you may take your position in the dock. Thank you.
Much obliged.
Thank you. Mr. Daniel, do you have any other witnesses?
Yeah. The defense counsel would like to proceed with the second witness of the defense. Mr.
You may call your second witness.
Tuan, we
Yes.
pray to call the defense witness number 2, Mr. Iwan Jusli.
Okay.
We pray to the court to present the witness statement of Mr. Iwan Jusli.
Okay.
The defense will display the witness statement of Iwan Jusli.
Okay.
Defense witness, please take your oath.
I do solemnly,
Who is
sincerely.
this? I can't see the witness statement. Witness.
I'm right here.
Intent.
Okay.
All right.
I can't see it on my screen, but it's okay. Proceed.
Okay. I do solemnly, sincerely, and truly declare and affirm that the statement I shall give shall be the truth, the whole truth, and nothing but the truth.
Okay.
We pray to the court to proceed with the examination in chief.
Yeah, sure.
Mr. Iwan, please introduce yourself before the court.
My name is Iwan Jusilin, 49 years of age, and I'm currently working as the operations manager of Suku-Suku Locks in Berhad.
Mr. Iwan, for the purpose of this trial, I refer to you to this witness statement. Did you prepare the witness statement?
Yes, I did.
We pray to the court to read the witness statement prepared by the witness. Mr. Iwan, why are you here before the court today?
I am here to testify before the court for Mr. Alan Kusuma, the Chief Operating Officer of Suku-Suku Locks in Berhad, who has been alleged for committing an offence on 5 April 2021.
Please explain what happened on that 5 April 2021.
Our workers were busy doing forestry clearing in the morning of that 5 April 2021 at the Tangkulak Forest Reserve area. And then they were stopped from doing their work when there were about 4 Telupit forestry officers suddenly approached them. One of the Telupit forestry officers, named Richard Lee, asked our site supervisor, Mr. Mark Angus, to show him the work permit to do such forestry activities. And then Mr. Mark Angus gave him the photocopied version of the permit. Later, Richard Lee told Mr. Mark Angus that the work permit provided was a forged permit, and there was in fact no approval obtained from the Chief Conservator of Forests.
Mr. Iwan, do you have any knowledge about the permit?
Yes, the obtaining of the permit by our company, Suku-Suku Locks in Berhad, is in pursuant to the terms stated in the contract between Suku-Suku Locks in Berhad and Maju Magasin Berhad. The permit is used to enable our company to fell the trees within the Tangkulak Forest Reserve area.
Could you tell the court who obtained the permit?
The permit has been obtained by Mr. Alan Kusuma, the Chief Operating Officer of Suku-Suku Locks in Berhad, on 16 March 2021, where he also asked me to immediately verify the permit with the Telupit Forestry Office, which was the next day.
What did you do after receiving the instruction to verify the permit?
I went to see Mr. Bonaventure Sipaun, the Telupit District Forestry Officer, in person on 17 March 2021 at the Telupit Forestry Office.
For the purpose of this competition, this defense will not tender this witness statement as evidence. I will pray to the court to proceed with some additional questions.
Yes, you may.
Okay. Instructing solicitor, could you scroll to answer number 3? Okay. Mr. Iwan, referring to answer 3, why did Mr. Mark Angus produce a photocopied version of the permit?
Because it has always been the policy of our company to let the site supervisor bring the photocopied version of the permit instead of the original one, as we keep the original one at our Kota Kinabalu's office.
What did Mr. Alan do when you informed him about the forged permit allegation?
When I called Mr. Alan Kusuma to inform him about the forged permit allegation on the 5 April, Mr. Alan had asked me to verify the validity of the said permit once again with the Telupit District Forestry Officer, Mr. Bonaventure Sipaun.
What did you do after the call with Mr. Alan?
Since Mr. Alan Kusuma had asked me to verify the validity of the said permit with the Telupit District Forestry Officer, I made a phone call to the Telupit Forestry Office.
Could you clarify what happened during the call?
Apologies, Tuan.
Yes.
The prosecution would like to object on the grounds that the defense is deviating from the facts that is presented to the prosecution.
What is the deviation?
Earlier, the defense counsel asked the witness when was the exact date Mr. Alan Kusuma asked the second witness to verify the permit. And the reason why they asked for verification of permit was because he found the permit was to be fake. And the answer given by the witness was 17th of March. However, the 17th of March correspondence between Mr. Alan Kusuma and the second witness is not on the validity of permits on the grounds of fakeness. The fakeness hasn't been established on that date, and this is the deviation.
Okay, they can submit later, but the thing is this question being raised in the examination, cross-examinations?
Apologies, Ton. Are you asking if I'll be addressing the question?
Has your counterpart have raised it in the cross-examination?
No, Your Honor. Ton. This
It was
question-
not raised?
It was not raised earlier because the proper facts was not on the 17th of March. And this is why I'm...
Yeah, but that is up to them whether they want to actually go on that line. But the more important facts is whether they have been raised, this question being raised in the cross-examinations.
However, Tuan, to answer your question, in the cross-examination, apologies, during the examination in chief as well as the cross-examination of the first defense witness, Mr. Alan Kusuma stated that the correspondence between the first witness and the second witness was only to ask the second witness to verify the permit.
Oh, that can, you can, prosecution can submit that later during the submissions. You can put it in the submissions. That's not an issue. Okay, just that an objection can be raised if the question was not raised in the cross-examinations. Then I can actually look into it. If the question is being raised, then they are bound to re-clarify. They're bound to clarify that during re-examinations.
Much obliged.
Okay, Daniel, has the question being raised in the cross-examination? Daniel?
Yes, Tuan.
Has Ms. Lim raised this question during cross-examination?
No. No, Tuan.
She didn't raise it.
No.
If she didn't raise it, then why you want to bring it down? You can't bring it down. That's the rule of evidence. Right? Unless you want to rephrase it to fit into what she have raised during cross-examinations. Okay? So you like to withdraw or you want to rephrase it?
The defense would like to withdraw.
Withdraw the question. Fair enough. Okay. You can
sorry,
proceed with the other line of questioning. Thank you.
Sorry, Tuan.
Yes, Aiman.
Can this defense counsel make some clarification?
Yes.
Okay. The question is actually to establish the existence of Mr. Bonaventure.
Okay. Has this question been raised during cross-examination?
During cross-examination of the previous witness, is it? Sorry.
Yes, yes, yes. For this particular witness. Okay. Now, by the previous witness, you're not bound by it, but this particular witness, okay, you are doing examination chief, right?
Yes.
Okay. Has these questions, because Mr. Jaya said that, this question is deviation of facts. Has this particular issue being raised at any point of time to any witnesses? Or is this or on facts?
No.
It was not raised.
Yes.
So what is Mr. Jaya saying now? He is saying there is a deviation of facts. Can you all explain what is the deviation of facts here?
Tuan, the question is for Mr. Jaya or me? Sorry.
No. Mr. Jaya, I've already explained the deviation of facts. Okay. Can you all reply to what he's saying?
Okay. I think they might. My apology, Tuan. Actually, the question here is on what happened on the 5 April 2021. So I think there might have been a confusion because there was a verification made before that date. So for this one, is on the date of 5 April, not the one during 17 March.
Okay.
So the question is to explain the conduct of the witness during the arrest happened. what did the witness do when the arrest happened on the 5 April?
Okay, so it's relevant. Is that what you're saying?
Yes.
Relevant to be
explain-
established.
Yeah, to explain the
never mind.
conduct of the witness.
Mr. Jaya, you can actually, you or your counterpart can actually question during cross-examination later. At the moment, we allow the questions by the defense.
Certainly, Tuan.
Okay.
Much obliged.
Thank you. All right. Okay, you can proceed.
Much obliged, Tuan. Mr. Iwan, could you clarify what happened during the call?
When I made a phone call to the Telukit Forestry Office to get the verification once again with Mr. Bonaventure Sipaun, they told me that Mr. Bonaventure has already passed away on 28 March 2021.
Mr. Iwan, earlier, during the reading of the witness statement, you mentioned about your role as the operations manager of Suka-Suka Lok Sdn Bhd. Under usual circumstances, could you explain what you usually supervise?
My job scope involves me overseeing the operation at the sawmills, supervising our employees at the mills, and also supporting workers' communication with the management team. Since our company is a holder under the Sustainable Forest Management License Agreement, I also have to ensure that our company generally follows the sustainable forest management principles to maintain the environmental values of all types of forests.
Referring to answer 4, did you have any knowledge about the contract between Suka-Suka Lok Sdn Bhd and Maju Megah Sdn Bhd?
I only know that the contract was awarded to our company by Maju Megah Sdn Bhd for the cutting down of trees.
You all must understand, when you all propose a witness statement, okay, you all at verbatim, you must read out the statement. You see, you cannot put a question and without referring to the witness statement. Unless and until I've told this many times, unless you have fresh questions, which you could take on later at the end of your questions in the witness statement. Other than that, in a natural proceedings, you must stick to the witness statement. If the witness statement say A, your answer should be ad verbatim to be repeated as what being stated in the witness statement. Okay? So I don't see, if you see like what Mr. Aiman is stated there in the question 4, Mr. Avon, do you have any knowledge about the permit? You cannot change it to contract. You get what I mean? Okay, stick to the question and then follow up with the answer. It's basically a written question and answer. You just have to read out for the purpose of satisfying the procedure and evidence under the law. Okay, so yeah, just stick to that. Thank you.
Tuan, we wish to explain and justify what the question was. As you can see in answer 4, it is stated that the question is not about the permit, but it is about the contract.
If it is not about the permit, then please ask leave from the court to actually amend the witness statement. Okay?
Even if this is additional questions?
If it's an additional question, you finish off your witness statement, then you inform the court that this is an additional question. So we all will be on the same page. Would that be okay? Have you finished the witness statement, Mr. Aiman?
Yes, I've addressed to the court that we have finished.
Then why are you going back to question 4 now?
It is about a contract because on the witness statement.
Enough. When you're going back to the question 4, are you referring to the question or you are actually coming up with the fresh question?
It is a question to the answer, not question to the question. It question to the answer.
Or you are asking your witness to explain the answer to question 4.
Yes, Tuan.
Over and above what is being stated here. Am I right? Over and above what is being stated here in the witness statement,
yes, Tuan.
right?
Yes.
Okay. So you got to make it very clear, okay, that in reference to question 4, okay, and the answer given, this is our fresh question. Then you go on. So all of us will have that. You know, we all will be in the same page of what is happening. Okay, instead of us jumbling up, jumping everywhere. Right? Okay, that's for
Right.
guidance. Thank you,
Okay.
Aiman. You can proceed. You are at liberty to proceed with all your fresh questions.
Stand guided, Tuan.
Thank you.
Masya blush. Okay. In reference to question 4 and answer number 4, you mentioned about the obtaining of the permit is in pursuant to the contract between Suka-Suka Lok Senjam Berhad and Maju Megah Senjam Berhad. Did you have any knowledge about the contract between Suka-Suka Lok Senjam Berhad and Maju Megah Senjam Berhad, Mr. Iwan?
I only know that the contract was awarded to our company by Maju Megah Senjam Berhad for the cutting down of trees in Tangkulak Forest Reserve so that Maju Megah Senjam Berhad can develop exclusive chalets there. The terms in the contract include that the forest clearing must be performed within 6 months from the signing date and the obtaining of the permit must be performed by our company. Besides, there was also instruction given by Maju Megah that our workers must comply. I do not know any specific content of the contract as it is a matter between Mr. Alan Kusuma, the Chief Operating Officer of our company, and Dato' Ahmad Zamani, the Chief Executive Officer of Maju Megah Senjam Berhad.
For clarification's purpose, this is an additional question. What was the specific instruction given by Maju Megah Senjam Berhad?
We were informed to not remove the felled trees as Maju Megah Senjam Berhad will use the felled trees to erect their exclusive chalets.
In reference to question 6 and answer 6, Mr. Iwan, you said that you went to see Mr. Bonaventure Sipaon. Mr. Iwan, did you have any knowledge about Mr. Bonaventure Sipaon?
I only know that Mr. Bonaventure Sipaon was a Telupit District Forestry Officer. He was the person who verified our permit on the 17th March 2021. And a week later, he also verified the marking done by us at the respective license area to determine the permitted logging areas.
For clarification purpose, this is an additional question. Was there anything else that Mr. Bonaventure did for you?
No. Again, Mr. Bonaventure only verified the permit and verified the limit of the permitted logging areas. After that, we did not encounter each other anymore.
You mentioned just now that Mr. Bonaventure verified the permitted logging areas. Why did Suka-Suka Lok Senjam Berhad make the identification of the respective permitted logging areas?
Sorry, could you please rephrase the question?
You mentioned just now that Mr. Bonaventure only verified the permit and also verified the limit of the permitted logging areas. My question is, why did Suka-Suka Lok Senjam Berhad make the verification to the permitted logging areas?
Because we needed to ensure that the conduct of our company followed the law to do the logging activities. It is part of our company's SOP. Besides, we were also aware of the status of the forest. The area in which the forest clearing needed to be done was within the Tangkulak Forest Reserve area.
Mr. Iwan, when you stated that you met Mr. Bonaventure Sipaon, was there anyone else?
No, it was just us two.
Could you explain to the court what happened during the meeting with Mr. Bonaventure Sipaon?
The meeting with Mr. Bonaventure Sipaon was to verify the validity of the said permit and also to discuss some matters pertaining to the work that will be carried out at the site.
Tuan, with that, we conclude our examination in chief.
Thank you. Any cross-examination?
Yes, Tuan. Tuan, the prosecution would now like to begin the cross-examination of Mr. Yuan Jocelyn. With the court's permission, may we proceed?
Proceed.
Much obliged, Tuan. Mr. Yuan Jocelyn, you are the operations manager at Suka Suka Log Sdn Bhd, is that correct?
Yes, correct.
And you are working under the instructions of Mr. Alan Kusuma, who's the first defense witness, is that correct?
Yes, correct.
Which means you are his employee, is that correct?
Yes, correct.
At the Tangkulak Forest Reserve, you as the operations manager have instructed Mark Angus and the 4 other general workers to carry out the operations, is that correct?
Sorry, could you please rephrase the question?
Sorry, certainly. You are the operations manager. You mentioned that earlier. Just to understand you correctly, is that correct?
Yes.
As the operations manager at Suka Suka Log, you instructed Mark Angus and the workers there to proceed with the operations, correct?
Yes.
Yes. And these operations that you just agreed to happened within the Tangkulak Forest Reserve, is that correct?
Yes.
You received a phone call from Mr. Yuan Jocelyn on the 16th of March, 2021, is that correct?
Yes, correct.
And on that phone call, Mr. Yuan Jocelyn told you that he wanted you to have a meeting with Mr. Bonaventure, is that correct?
Yes, correct.
Would you agree with me if I told you the reason why he wanted you to have this meeting with Mr. Bonaventure is because he suspected the permit might be fake or might be forged, is that correct?
No, I disagree.
Your Honor, at this juncture, the prosecution would like to point out that this is a contradiction with what was answered by the witness during the examination in chief.
Oh, okay. You can submit later. That's not a problem.
Oh, that's not a problem.
Yeah.
Much obliged, Tom.
That is okay.
Moving forward, Mr. Yuan. After this phone call on the 16th, on the 17th, you met with Mr. Bonaventure, correct? As per the instructions of Mr. Allen, who's your boss. Mr. Yuan?
Sorry, could you please rephrase the question again?
Yes, certainly, no problem. Earlier, you said on the 16th, you received a phone call from Mr. Allen, correct, right?
Yes.
And the nature of the conversation is that Mr. Allen wants you to have a correspondence, a meeting with Mr. Bonaventure, correct? On the 16th.
Yes, he asked me to verify the validity of the said permit.
Yes, please, I don't require further explanation, just answer yes or no. So on the next day, which is on the 17th, you met with Mr. Bonaventure. This correspondence actually did happen.
Yes.
And based on this correspondence, Mr. Bonaventure concluded that the permit is valid. Is that correct?
Yes, correct. He showed me the register of the approved permit.
Yes. With the court's permission, the prosecution would like the witness to have a copy of the Form 11A, which is the permit, to be presented. Instructing solicitor, please assist.
It's already a part of the evidence, right?
Sorry?
It's an evidence, right? It's a court evidence.
It was a court evidence. Both parties have access to it.
Okay. P, what is that?
One moment. It should be ID 3.
ID 3. Can the instructing solicitor flash it on the screen?
Okay. Mr. Yuan, is this document very clear to you? Can you see every single word that's displayed?
Yes.
Okay. It is stated there on this document, Borang 11A, lesen mengambil keluaran hutan bebas dari royalty. Is that correct?
Yes, correct.
Okay. At the second line, we can see clearly, lesen ini membenarkan Alan Kusuma. That is your boss name. Is that correct?
Yes, correct.
And further at line 4, untuk memotong, mengambil dan memindah keluaran hutan simpanan Tangkulak kawasan. Is that correct?
Yes, correct.
And further below, we go further down, dari hutan simpan Tangkulak dalam daerah Telupit. Is that correct?
Yes.
Mr. Yuan, can you confirm that this is the exact same Borang 11A you showed Mr. Bonaventure, who's the person that you met on 17th?
Yes.
And this is the exact same borang that Mr. Bonaventure used to confirm that this form 11A is valid and your company name is registered there in the registry. Is correct. Okay. With the court's permission, instructing solicitor, please don't take it down. With the court's permission, we would like to also display the letter that was received by Mr. Ahmad Ladidu, which was previously tendered to the court as Exhibit P7.
Okay, P7, please display.
The court permission, I'd like to display by sharing a screen.
Okay, Mr. Yuan, can you see both of these documents clearly? Is every word legible, visible to you clearly?
Could you please zoom in a bit?
On which document specifically? The one on the left, right?
Yes, the one on the left.
Okay. Instructing solicitor, please assist. Okay.
Make it clear so the witness could see.
Yes. Mr. Yuan, is it clearer now? Can you see every word? Okay, thank you. Okay, Mr. Yuan, just to be clear, earlier you said you met with Mr. Bonaventure on the 17th, and Mr. Bonaventure confirmed that the Form 11A, which you can see on the left side, is valid and your company name is registered already. Can you also confirm that Mr. Bonaventure is the Forest District Officer who works for the Teluk District Forestry Department?
Yes.
Okay. Now, Mr. Yuan, on the right side document, this is the document that confirms the status of the Tangkulak Forest Reserve as a forest reserve. For the purpose of clarification, the one on the right, the document on the right, is a document from the Sabah Forestry Department that specifically points out the exact area of the Tangkulak Forest Reserve. Tangkulak Forest Reserve is where the incident took place, where the illegal logging took place.
Okay.
That's for the purpose of clarification.
Okay.
This was issued by Harisa Marisa. Harisa Marisa is acting on behalf of the chief conservator at the department.
Okay.
Document on the left is the alleged fake permit. So with that clarification out of the way, we'll proceed with the questioning of the witness.
Please.
Mr. Yuan, on the document on the right, okay, I'm referring to the second paragraph, berikut adalah maklumat, okay? I'm referring specifically to keluasan. We can see here the keluasan is 27,258 hectare. Okay, so according to the department, the Tangkulak Forest Reserve has an area of 27,258 hectare. Now, for further clarification to the court, if we were to convert the value in hectare to square kilometers, it would amount to about 270 square kilometers. Further, on the document on the right, Ms. Yuan, you can see clearly, Mr. Yuan, you can see clearly that the keluasan listed there is 1,300 square kilometers. Is that correct?
Yes.
And the document on the right states an area of 27,258. Is that correct?
Yes, correct.
And Tuan, as previously pointed out, the area 27,258 converts to about 270 square kilometers. Now, Mr. Yuan, would you agree with me if I were to put to you, there's a clear discrepancy in the area of the forest reserve between these two documents? Would you agree with me? Mr. Yuan?
Yes, I agree.
Thank you, Mr. Yuan. With the court, apologies. Mr. Yuan, earlier you also mentioned that Mr. Bonaventure approved this permit, correct? Did I understand you correctly? Now, if I were to put to you as a district forest officer, as a member of the forestry department, he would have been able to pick up this discrepancy, this mistake that you can see on the left side of the screen. As a forest district officer, he would have been able to pick it up. Would you agree with me on that?
Yes, I agree.
Thank you. Further, because you answered A, yes, I have one further question. Would you agree with me that if the Sabah Forestry Department actually received the Form 11A, because of this discrepancy, they would not have approved it. Would you agree with me?
Objection, Your Honor.
Yes.
Objection, Tuan. Sorry.
Yes, yes.
The comparison made is irrelevant because
Okay.
the permit issued is for a specific location, while the letter of confirmation is for the whole forest reserve. So the comparison is irrelevant.
One.
But they're raising it during the cross-examination. So I think we can give them some allowance. You can clarify that during re-examinations. Yeah. Yes.
Much obliged, Tuan.
Yeah. Thank you. Yeah. Proceed.
Mr. Yuan, the document on the right, which is the letter that was received from the department, which shows the whole area of the Tangkulak Forest Reserve, the value listed there is 270 square kilometers based on the conversion, which I mentioned earlier. Would you agree with me?
Yes, I agree.
However, if we look at the permit that you received, the value is much higher, which is 1,300 square kilometers, which is well above the value listed in the document on the right. Would you agree with me on that? Number 1,300 is higher than 270. Would you agree with me on that?
Yes, I agree.
Okay, one follow-up question based on this. Would you agree with me if the Forestry Department in Sabah actually received the document you see on the left, they would have not approved the permit because of this discrepancy? Would you agree with me on that?
No.
With the court's permission, we'd like the witness to have a copy of the map for the Tangkulak Forest Reserve, which was previously admitted to the court as Exhibit P1. Sorry, Tuan, it's Exhibit P2. Mr. Yuan, can you see this document clearly?
Yes.
Can you point to me, okay, since earlier you told me that you were with Mr. Bonaventure and you approved the permit, correct? Right?
Yes.
And you also managed to go with Mr. Bonaventure to the Tangkulak Forest Reserve, right?
Yes, correct.
So if you have been to the Tangkulak Forest Reserve, can you point out the location of the Tangkulak Forest Reserve in the map?
The one that's been colored with blue.
The one that has been colored with blue.
Yes.
Is it located just in the color of blue, or would you say that if I were to put to you that it's not limited in the color of blue, it extends well beyond that, would you say yes or no?
Sorry, could you please rephrase the question again?
Earlier, you said the Tangkulak Forest Reserve is just listed, the permit that you received for for the deforestation in the Tangkulak Forest Reserve is just in the blue spot, or does it extend beyond that?
It extends beyond.
It extends beyond. Okay. Tuan, that concludes the cross-examination of the second defense witness. Much obliged.
Thank you. Re-examination.
We pray to proceed with the re-examination question.
Yes, Aiman.
Mr. Yuan, just now you answered to the cross-examination question about the permit, whether the permit ID3 was the same permit that you referred to Mr. Bonaventure Sipaun on 17 March. Could you elaborate further on that?
Yes. The permit is exactly the same with the one I witnessed at the Teluk Forestry Office, which has been shown by the Mr. Bonaventure Sipaun, the Teluk District Forestry Officer.
That is all the question for re-examination.
That's all, huh?
Yes.
Yeah. Any if there is no questions, yeah. Applications for the witness. Is there anything, Aiman?
We pray for the witness to be released.
Okay. Mr. Yvonne, you are released. Thank you for the cooperations.
Much obliged, Tuan.
Thank you. Prosecution. Do you wish to address the court?
May it please this court, Tuan, my name is Jaya, and I appear before this court now to conduct the closing submission for the prosecution.
Okay. Before you before you proceed with your submissions, prosecution, Ms. Lim, since you are the lead prosecutor here, you must always inform the court that you wish, okay, okay, for the submissions to be made, okay. But before that, Aiman, or who is this lead counsel for defense, Daniel, you must inform the court that you have no other witnesses to be called and you pray for the defense case to be closed. Okay, then we all can proceed for submissions. Okay, Daniel, Aiman, yeah, aware of that. Okay, since the rules of the competition is only limited to 2 witnesses. Okay, though we are all aware of that rule, but you have to inform formally to the court that you have no other witnesses to be called. And if there is any in the natural proceedings, if there are any witnesses that you wish to offer, or I mean that doesn't apply to defense. For the prosecution, okay, in the future, be reminded, if you have a string of witnesses and you only have called some of them, and some of them are not made available to the to be called, you can always offer to the defense at the end of your prosecution's case. Okay, it's just for guidance. All right. So I assume that defense have no other witnesses and they pray for the defense to be closed. So therefore, I call upon prosecutor, Mr. Jaya, okay, to submit on this case.
Tuan, before I proceed, would the court require the skeletal submission of the prosecution to be displayed?
You have submitted to the court, right? The submissions?
Yes, that's right.
Okay. What you can do is, if you want, you can actually screen it.
Okay.
Or publish to see.
With the court's permission, I request the instructing solicitor for the prosecution to display the skeletal submission.
Okay. Thank you.
Tuan, in this case, Mr. Alan Kusuma, who is the
before that, how long would it take for this purpose of the submissions?
Apologies, the whole submission should take 20 minutes.
Okay, thank you.
And that also applies to the defense as well.
Fair enough. Thank you.
Tuan, in this case, the elements for which Mr. Alan Kusuma, the accused, is being charged is listed under Section 20, subsection 2 of the Forest Enactment 1968. The Forest Enactment 1968, specifically Section 20, subsection 2, lists out 4 elements in total. The first element is there was an act of cutting down trees. The second element is that the accused had no lawful authority to cut down the trees in the forest area. The third element is that Mr. Alan Kusuma had himself or through his agents committed the act of cutting down trees. And finally, the act of cutting down trees happened within a forest reserve. So with that, let's proceed to the first element of the charge, where there was an act of cutting down trees. Now, based on the witness statements given by Mr. Richard Lee, Mr. Ahmad Ladidu, as well as the defense witnesses, which is Mr. Alan Kusuma himself, who is the accused, and the second witness, who is Mr. Yuan Yuslin, all of the witnesses adduced to the court, as well as all of the evidences adduced, all point to the fact that there was an act of cutting down trees. There is no dispute as to that on either side of the court. The prosecutions agree to it and the defense also agree to it. We can see that there was an act of cutting down trees based on the pictures that was adduced to the court earlier under ID 5. Additionally, the police report that was tendered to the court as P6, you can see the number of logs, which shows that the trees were cut down at the Tangkulak Forest Reserve. And next, we can also see that in the notice of seizure, you can see 70 kayu bala as well as agarwood, 131 logs of agarwood that were confiscated in the Tangkulak Forest Reserve. Now, all of these evidences that I pointed out all show that there is conclusively an act of cutting down trees. That has been established by the prosecution, and that has also not been contested by the defense in any way. Moving on to the second element, which is that the accused had no lawful authority to cut down the trees in the forest reserve. Based on the testimony given by Mr. Ahmad Ladidu, as well as the testimony of Mr. Richard Lee, they both stated that they found the permit to be fake. They found the permit to be forged. They found that no application was received at the department or the forestry office. They found that no permit was even issued. So, Tuan, firstly, there was no application received by the departments or the forestry office. And secondly, no permit was ever issued. If we were to look at the witness statements given by the first defense witness and the second defense witness, both of them stated that they have asked Mr. Bonaventure to confirm the validity of the permit. And Mr. Bonaventure has confirmed the fact that the permits are indeed valid. However, referring to the witness statement that is given by the first prosecution and witness and the second prosecution's witness, what is stated by the defense cannot stand because no application was ever received in the first place. And secondly, no permit was ever even issued. Now, even if we were to assume that the defense has approached Mr. Bonaventure to verify the validity of the permit, even if we were to assume that, the fact that the permit was allegedly issued and verified showed that no application was made. And the reason for that, to illustrate further, I request the instructing solicitor to display once again the Form 11A and the letter received by Mr. Ahmad Ladidu.
With the court permission, I would like to display the license and letter.
Instructing solicitor, can you display?
Yes, but technically it's a technical issue.
Tuan, while the instructing solicitor is tending to this, I'll proceed with my submission.
Okay.
The point I'm trying to make based on the Form 11A and the letter received is that the letter that was received by Mr. Ahmad Ladidu, the second defense prosecuting witness, it shows that based on the calculation of the Sabah Forestry Department, the whole area of the Tangkulak Forest Reserve is only 270 square kilometers. However, if we were to look at the Form 11A that is the allegedly fake permit that's adduced by the defense and the prosecution, the area of the Tangkulak Forest Reserve is significantly higher. That is impossible to be the fact. If the Tangkulak Forest Reserve or the Sabah Forestry Department had actually received the permit in the first place, they would have never approved it because the area listed in the permit is 1,300. How can that be so when the Tangkulak Forest Reserve is only 270 square kilometers? It makes no sense, Tuan. Now, the figures can be seen at the right, where it's stated keluasan 27,258 hektar. And if we were to convert that, it would mean 270 square kilometers.
Mr. Ganesh, has this question been put to the IO earlier?
IO, Tuan?
Yeah, to the, what do you call that? The IO of the case, Mr. Ahmad Ladidu.
Yes, Tuan, it has been.
Has been?
Yes.
What was his answer?
He said that there is a clear discrepancy in both of these documents.
Okay.
And this question was also posed to the second defense witness, and she agreed that there was a clear discrepancy. Further,
the second witness is defense witness or second prosecution witness?
Second defense witness.
That is, she is the operation manager, right?
Yes, sir.
Okay.
And to illustrate further, she's the person who received the permit from Mr. Alan Kusuma, the accused. She's the person who approached Mr. Bonaventure.
Mm.
The point here, Tuan, is that the prosecution submits there was first of all never a meeting with Mr. Bonaventure. Because if Mr. Bonaventure has seen the permit, he would have never approved it. Because there's a very clear discrepancy in it. We can see that there's a sign and there's a seal on the permit.
But Mr. Bonaventure was not brought into the court, right?
Exactly. He's already passed away.
Yeah.
Now, the sign and the seal would also not have been there if the Sabah Forestry Department has actually received the permit. Now, the reason why I say that to further home in the point is because Form 11A gives the defense, Mr. Alan Kusuma, the jurisdiction to conduct deforestation for an area of 1,300 square kilometers, which is significantly higher than the actual area of the Sabah Forest, Tangkulak Forest Reserve. And that is the reason why we say the prosecution submits that no permit application was made, no permit was actually given. As such, it is also our submission that the accused has conducted the activities of cutting down trees without proper permit. Further, Tuan, referring to section 36, subsection 1, paragraph A of the forest enactment, any forest officer at the site can stop anyone and request for a permit. And if he suspects that a forest offense has been committed, he can immediately seize or arrest the personnel who are involved in the forest offense. And further, if we were to look at section 36, subsection 1,
but their contention is, Mr. Alan Kusuma was never at the scene of the crime,
yes,
where the logging happened, illegal logging happened.
Yes, sir.
So what is your say on that?
Certainly, Tuan. Can the instructing solicitor please scroll below? I'd like to address the point that was raised by Tuan. Further below. Furthermore, okay, can you stop at 1.4? Can you scroll below a little more? 1.4, okay. As you've pointed out, Tuan, the defense's argument is that Mr. Alan Kusuma was never at the Tangkulak Forest Reserve. However, within the provisions of section 32, subsection 1 of the forest enactment, it doesn't matter whether Alan Kusuma is actually at the site or not. All that matters for the prosecution to charge the defense and hold him accountable for his actions is that the act of cutting down trees at the forest reserve happened through his agents. Now, we have established through the cross-examination of the defense witnesses that Mr. Alan Kusuma instructed the second witness, which is Mr. Iwan Juselin, to act as the operations manager for this deforestation. And through the actions of the operations manager, the second witness, defense witness, Mr. Mark Angus and the 4 general workers who were at the site conducted the actions of cutting down trees. Now, this can be evidenced by the fact that through the cross-examination as well as the examination in chief of the first and second prosecution's witness, Mr. Richard Lee and Mr. Ahmad Ladidu, who both stated that Mr. Mark Angus was arrested, 4 general workers were arrested. When the question was posed to the defense witnesses, whether these people are the employees of Suka Suka Log, they both said yes. There's no argument against this contention, since the Mark Angus and the 4 general workers are workers of Suka Suka Log, employees of Suka Suka Log. They are in turn also employees of Mr. Alan Kusuma, the accused. As such, it is established that the actions of cutting down trees were done by Mr. Alan Kusuma, the accused, through his agents, who are Mark Angus and the 4 general workers. Further, Tuan, we will also not point to section 32, subsection 2 of the forest enactment, which states that if a forest offense is committed by a body corporate, such as Suka Suka Log, the director, the officer, secretary, any person involved in the body corporate as such can be held accountable. And the person that we specifically point today is Mr. Alan Kusuma, because Mr. Alan Kusuma is the chief executive officer. During the cross-examination, as well as the examination in chief of Mr. Alan Kusuma during the defense stage, he admitted to the fact that he is the CEO.
Mr. Jaya, what was your contention? What is your reply to the fact that, that you have taken steps to verify through Yvonne whether there was an application, whether there was a permission from the forestry department for them to cut the trees, and they've taken all the due diligence to verify this based on the registry that been shown by Mr. Bonaventure. Yeah, don't you think that they have taken all these steps to verify the permits, whether it's the authentication of these permits by the forestry department?
So, it is a prosecution submission that the defense cannot hide behind the argument that they took due diligence or had no knowledge of a fake permit. It is our submission today that the accused knew fully well, he was aware of the fact that the permit was fake, which is the reason why he felt suspicious of it and he contacted Bonaventure to verify the permit on the 17th. Now, if we were to refer to the examination in chief of Mr. Alan Kusuma, he stated that on the 15th, he received the fully filled out permit on the 15th of March. Now, if he had received a fully filled out permit that has been chopped and signed by the person acting on behalf of the chief conservator, which we would point out, by the way, that is he received it from a third party. He did not make the application himself. Now, if he received a full-fledged permit that is approved already, why would there be a need to request a simple forest officer to verify the permit when it is in fact been chopped and signed by the actual person acting on behalf of the chief conservator? Only the chief conservator and people who are authorized by him can actually sign. And
don't you think that by premised on that very same argument to show that they have actually gone further, they have gone to verify further on the genuineness of the permit?
Not at all, Tuan. We say that it is simply a cover-up, a farce to hide the fact that they have forged the document and are only relying on it to cut down the trees. The reason why we say that is because, as earlier pointed out, there are clear discrepancies in the Form 11A and the actual statutory document of Form 11A. That's the first reason. And this was also confirmed by our first and second prosecuting witness, who have pointed out that, apologies, Tuan, before I proceed, I would like the court's permission to display the Form 11A as well as the statutory document,
please,
because it'd be better for the clarity of. Instructing solicitor, please assist.
Yes, the court permission. I would like to display the document by sharing the screen.
Can you, instructing solicitor, can you please, I think it's fine. Tuan, allow me to proceed to my submission now.
Yes, yes.
Specific discrepancy that was addressed by the second and the first and the second prosecuting witness is referring specifically to, if I may quote from the statutory document on the right that you can see on screen, untuk memotong, mengambil dan memindah keluaran hutan. That is what is listed in the statutory document. Now, if we look to the left, untuk memotong, mengambil dan memindah keluaran hutan, simpan tangkulap kawasan. As rightfully pointed out for the first counsel for the prosecution, the ... and simpan tangkulap kawasan has been added to a statutory document to facilitate the purposes of the accused, which is Mr. Alan Kusuma, to conduct the deforestation within the Tangkulak Forest Reserve. That is the first evidence. The second evidence is the fact that if an application was actually made to the department, and if Mr. Bonaventure actually saw this document, he would have never approved it in the first place. The reason for that is because, first of all, the clear discrepancy between the statutory document, and secondly,
did the prosecution put to the prosecution witnesses, particularly the IO, in respect of these discrepancies?
Yes, the IO has identified both, apologies, the Form 11A. He has pointed out that there is an addition of words to the statutory document. Additionally, he has also pointed out the area listed.
What was his investigation on Eunice Marlis?
He called Eunice Marlis on the 12th of April to confirm. He also called Harissa Marisa. Tuan, we would point out here that both Eunice Marlis and Harissa Marisa are both acting on behalf of the Chief Conservator of the Forest Department. Now, this further points out the fact that if they actually got the application in the first place, they would have never approved it, which is the reason why the prosecution is submitting that no application was made in the first place and no permit was approved. And this is a forged permit.
So Eunice disputed her signature.
Eunice never disputed to her signature. She simply stated that no permit application was received. Which
whose signature was there in the permit?
That is her signature. But seeing that she denied the fact that there was no permit application being made, which means that she never approved the permit. She never received it.
Then why there is a need for her to place her signature on the document?
That is the reason why we're stating, Tuan, that no application was made. Because if he received it, she would have stated to the second prosecutor.
Okay, fair enough. If there is a no application, the certification should not be there. But in this particular instance, Eunice have confirmed that it is her signature. Although we don't have the privilege of looking and hearing the evidence of Eunice because the competition rules, but what is the investigating officer's view on this?
Tuan, before I proceed, it is important to point out that Eunice Marlis never said that that is her signature and she approved.
Oh,
this.
never said. She never said. She never
Okay.
said. Okay, okay.
Allow me
That's why I
to-
want to know that.
Allow
Because-
me to recreate the conversation with the second prosecuting witness,
Sure.
which is Mr. Ahmad Ladidu.
Sure.
I asked him specifically, why did you think the permit was fake? He pointed out to the clear discrepancies. Secondly, he stated that he made 2 phone calls. The first phone call was made to Harisa Marisa. The second phone call was made to Eunice Marlis. Eunice Marlis is the person's signature you see here.
Yeah.
Eunice Marlis picked up the phone and she said, I never received an application for that. And that answer corroborates with the first witness as well as the second witness. Both of them said no application was made. Both of them said no permit was approved by
So
her.
technically, they are saying that that is not their signature. It could have been forged.
Yeah, exactly, Tuan. It could have been forged, and that is what the prosecuting is submitting today.
Okay. All right.
Tuan, do you require any further clarification on this?
No, I'm good. I'm good. Is there any further submissions on this, Mr. Jaya?
Yes, Tuan. There is further clarifications on this. Can the instructing solicitor please revert back to the closing skeletal submission? Please display the section on the forest reserve. Tuan, while she is presenting, I would like to proceed forward. It is also the prosecution's duty to establish all of the elements. We have established the first element, that there was an act of cutting down trees. Second element, that there was no lawful authority. Third element, that Mr. Alan Kusuma was acting through his agents in cutting down the trees.
Yeah.
Now we come to the final element, which is that the act of cutting down trees in a forest reserve happened within the Tangkulak Forest Reserve. Instructing solicitor, please display the skeletal submission for the court. Now, the proof that all of these acts happened within a forest reserve is undisputed throughout the prosecution stage and the defense stage. None of the witnesses have stated anything contrary to the notion that all of these occurrences happened within the forest reserve. As such, we would point out that it is now the burden on the defense to prove to the court within Section 38 that the offense was not committed within a forest reserve, and additionally that they had a lawful permit. They also now have the burden on Section 38, subsection 1. Instructing solicitor, please scroll down to the end of the submission. Okay. Now, as below one, yes, here. Tuan, as the prosecution has established a case beyond reasonable doubt, where there is no contention against the points raised by the defense, we submit that the case beyond reasonable doubt has been established. For that, we pray that the accused, Mr. Alan Kusuma, be given the punishment of 20 years and a fine of 500,000 as listed in Section 20, subsection 2 of the Forest Enactment 1960. Tuan, that concludes the submission for prosecution. Much obliged, Tuan.
Thank you. Before letting you go, Mr. Jaya,
Yes,
don't you think that, Mr. Alan Kusuma and his company being duped by Dato' Kong in procuring the fake permit?
Apologies, Tuan. If I understand you correctly, are you suggesting that they have been fooled by Mr. Kong?
Yeah, that Dato' Kong have procured the fake permit. If it was so, being alleged by the prosecution, if that were the case, do you think that, Mr. Alan Kusuma and his company would not have any knowledge of the fake permit? What say you?
To address your question, apologies, Tuan, as stated by the first prosecuting witness, they have been friends for quite a long time, since primary school. Now, I agree that that is not conclusive proof of why Kong would not suddenly, try to backstab his friend. But if the defense wants to rely on this argument, they have to prove to the court that Mr. Kong had a motive, had an intention of double-crossing Mr. Alan Kusuma. Now, since Mr. Kong is not being brought to the court as a witness, and there's also no fact or evidence to suggest that he had an intention to act with malicious intent, their argument on this cannot stand, Your Honor. And
About that, we have Section 38 pointing at them, isn't it? They have the burden of proof.
They have the burden of proof to show that, but through the cross-examination of the defense 1 and defense 2, they have not shown anything, and also the examination in chief, they have not shown anything to suggest that Mr. Kong might have any malicious intents to act against the interest of Mr. Alan Kusuma.
Okay.
And rightfully pointed out by them, they have been friends for a long time. So I don't see a reason why they can rely on this defense.
Okay.
Much obliged.
Thank you. Thank you so much for the submissions. Very comprehensive submissions. We take it on to the defense to present the submissions. Thank you.
Tuan, We
Mr. Aiman, is it?
Yes.
Mr. Aiman? Yes, Mr. Aiman.
Okay. Tuan, we pray to the court to present the closing submission
Sure.
prepared by the defense.
Yes.
Yeah. Solicitor.
The defense will display the closing skeletal submission.
Mr. Solicitor, could you scroll to the grounds of defense? We pray to the court to proceed to read the closing submission.
Yes, please.
Based on the charge read to the accused and the ingredients specified under section 20, subsection 2 of the Forest Enactment, the defense submit that the failure of the prosecution officer to prove that there was no express authority to fell those trees, i.e. the fake permit, the failure of the prosecution to prove the act of cutting the trees and collecting the forest produce allegedly done by the accused amounted to 101 felled trees, the failure of the prosecution to prove that the alleged acts of cutting the trees and collecting the forest produce were committed in the accused logging activities areas and not elsewhere. And lastly, the failure of the prosecution to show to the court that one of the accused person committed the act and the others participated in furtherance of common intention in accordance to section 34 of the Penal Code. For the first ground, the failure of the prosecution officer to prove that there was no express authority to fell those trees, i.e. the fake permit. The charge under section 20, subsection 2 of the Forest Enactment is made after the permit in dispute was alleged to be a forged permit. However, the original permit ID3 has been produced before the court and the production of the permit has sufficiently proven that the permit in dispute was in fact not a forged permit. The accused has testified that the original permit was kept in the company's office at Kota Kinabalu. The production of ID3 by the prosecution has proven that the accused has in fact obtained a license or express authority required to cut down the trees in accordance to section 20, subsection 20. The details of ID3 are
Can I
Yes.
stop you there? You are saying that it's not a forged permit, but they have verified, prosecution have verified to their policy department, and it seems to suggest that it's a fake permit. What say you?
Tuan,
And they even have gone further to actually to show to the court, okay, not as a person as a cause of evidence, but as a matter of reference, they have shown between the fake permit how it looks like and also the genuine ones. So what say you on it?
Tuan, the verification made relied by the prosecution, which was by Ineos and the other person named Harisa. Those two witnesses, the verification made by them could not be relied by the prosecution as those people were not called to the prosecution.
But that is beyond their power, isn't it? That is the organizers. That is why I have reiterated my question earlier. You know who actually decides on the witnesses, and you all say the organizer decide on the witnesses, right? So we can't be putting the blame on the prosecution. It's not that they don't want to call, but their hands were bound by the rules of the competition. Am I right, Jaya Ganesh? Yeah. Yeah.
That is right.
You all can't be calling any witnesses, isn't it? Beyond what is being listed by the organizers. Am I right?
We can only call the witnesses that they asked us to call.
Yeah, they asked you. So it's unfair for us to now to pinpoint to the prosecution that they didn't call these people, that people, and all that, and to draw adverse inference under 14G, right? So yeah, so I don't think so. We want to pursue that argument. Okay, yes, Aiman, proceed.
Tuan, if I may clarify.
Yes.
Because on the arguments that you mentioned just now, which is the limitation put by the organizer, that is why the defense believe that to say that the prosecution has gone further to make verification of the permit is actually quite unfair for the defense. Relying on the fact of the...
But they have called up with IO, and the IO came to court.
But not Eunice Marlies.
No, the second witness for the prosecution, who is the IO, right? Inci Ahmad, came to court and he verified and he was not being challenged so much on his verification. And he did say that, that it is a fake permit. And he did make comparison. And he did also illustrated what actually transpired and his conversation with Eunice and also, who is the other person? Eunice and one more person is who? Which Marisa is that?
Tak, Eunice mana ada?
Who the other two person? He verified with Eunice. Who the person who signed the letter, the permit? What's the name? I'm asking you all a question. Who is the person who actually signed the permit? The fake permit?
Sorry, Tuan, are you addressing the question to me or the prosecution?
Yeah. Either one of
okay.
you or the prosecution. Who is the person who actually signed the permit?
It's Eunice Marlis.
Eunice, isn't it? Huh?
Eunice is not here.
So did the investigation was made? Jayaka was telling that investigation was made against her as well. And she disputed. That is her signature. And there's another person also. What is another person's name? Who's the other person?
So on that ground, Tuan.
No. Answer my question. Who's the other person apart from Eunice? Who is representing the conservator?
Marisa, sir.
Marisa. See? So these two people were investigated.
Tuan, that is on that ground. That is why the defense said that it is unfair for the prosecution to rely on the verification made by those two people because of the limitation by the organizer. Because the defense
we can't go on that line. We can't be that you have to take it up to the competition organizer. Okay. So in fact, I sympathize with you people, because of the right of choice of witnesses should be given to the participants. I agree, fully agree, but it's beyond my limit. I'm not the organizer. So yeah. So that is something that you all want to take out later to the organizer, why they limit it, instead of allowing you people to actually decide who you all want to bring in. Okay, even if you want to limit the numbers, that's fine. But the choice should be given to you guys. Okay, that is I perfectly understand. But at this juncture, it's not fair to actually pinpoint that prosecution is not being fair, because their hands were tied as well because of the rule of competitions. You see, even they wanted to bring in this Eunice and whoever, they can't. Okay, because that decision was made by the organizer. So I don't think so. We want to go on that line. All right. Okay, Aiman, proceed.
Okay, Tuan. Mr. Solicitor, could you scroll to number 16? Yeah, number 16. Okay, paragraph 16. Okay, thank you. Upon the approval of ID3, the accused has conducted his best due diligence to confirm the validity of the permit. The accused had immediately instructed his experienced operations manager to verify the validity of ID3 on the same day when the accused had obtained D1 from Datuk Kong on 16 March 2021, despite the assurance given by Datuk Kong. The accused ensured that the verification was to be made by an authorized person, i.e., a Telupit District Forestry Officer, Mr. Bonaventure Sipaon. DW, Mr. Iwan, had later informed the accused that the ID3 had been verified by the Telupit District Forestry Officer. Hence, the verification of the validity of ID3 had been done. To the knowledge of the accused, he had obtained the necessary permit to cut, collect, and transport any forest produce from Tangkulak Forest Reserve in accordance to Section 20, Subsection 2. There was, in fact, a license or express authority issued to the accused. The defense is aware of the reliance on Section 31, Subsection 1, which put the onus of proving the existence of the license to the defense. Mr. Solicitor, could you scroll to number 20? Okay. In addition to the submission that the accused had conducted his best due diligence, Section 114 illustration paragraph E of the Evidence Act, the court may presume the existence of any fact which it thinks likely to have happened regard being had to the common cause of natural events, human conduct, and public and private business in their relation to the facts of the particular case. The court may presume that judicial and official acts have been regularly performed. This shows that the accused relying on the verification made by the Mr. Bonaventure is in line to the law. Alternatively, the defense submits that the prosecution alleged that the permit issued by the accused is a fake permit, and the onus to prove that the permit in dispute is a fake permit is under the duty of the prosecution. In this case, the prosecution must prove affirmatively that the permit is a fake permit. The prosecution must...
Mr. Aiman, how you suggest them to do that?
Tuan, if I may suggest, it should actually be another charge on forgery, and it should be fulfill the elements of forgery. However, in this present case, the prosecution has never fulfilled all the elements necessary to admit that the permit was a forged permit.
Yeah, so but how you suggest them to do that? How you suggest them in the scope of this competition? How you suggest them to do that? They can't go beyond what is being laid out by the organizer. How you suggest them to do that?
They must show...
I know it's a pretty unfair leverage. I can appreciate that. How you expect the prosecution to prove that this is a fake permit?
To prove
the only people that been brought in by the prosecution is the IO. And of course, the other person, the forest officer. But the IO is the crucial person, the main person embodying the investigation for the prosecution. So yeah, that is the only person that were carrying the strength of this case in this proceeding. So how else you want them to prove? They can't be bringing an expert. That is not allowed in the competitions. Okay.
The defense suggests that at the very least, the prosecution could have proven the element of forgery.
Yeah. That I know. I'm well aware of that. I keep on repeating that. Yes, but how you want them to prove? How you want them to prove? The only thing is by making bringing in an expert witness, either handwritten experts or any documentary experts, to verify the document. That is the only way. Okay. And no questions were advanced during cross-examination to the IO in respect of this. No question during cross-examination were advanced in this line. There were no steps taken to approve the forgery of this document. Right? Correct me if I'm wrong. Yeah. So no lines of questioning being taken on this ground even for the court to consider. See? But anyway, it doesn't matter. I appreciate that. Yeah, move on, Aiman. Thank you.
And Mr. Solicitor, could you scroll to the ground number 2? Okay. Sorry, could you scroll to ground number 3? Okay. Failure of the prosecution to prove that the alleged... Okay, all right. Then we proceed with the closing submission. The other ground relied by the defense is the failure of the prosecution to prove that the alleged acts of cutting the trees and collecting the forest produce were committed in the accused logging activities area and not elsewhere. The brief details relied by the prosecution on the police report, map, photos, but we will address one by one. So the brief details that is mentioned as of the evidence admitted on the police report are insufficient to prove the alleged offense was related to the accused business in the Tangkulak Forest Reserve. This raises question that were the arrest and seizure in the police report really made in the area where the accused had obtained the permit to cut, collect, and transport the forest produce. If it's so, were the logs and the items in the photos related to the accused business in the Tangkulak Forest Reserve. During the raid, none of the forestry officer testified that they did take GPS coordination, but the prosecution did not admit any evidence that can clarify the GPS coordination as argued. Scroll to number 38. Okay. The map admitted by the prosecutor that lacks of the longitude and latitude also could not confirm specifically where the alleged offense took place. The evidence of the map and the letter from the forest department to the investigation officer are merely evidences which are not proven accurately on the location of the alleged offense. Lastly, on the ground of the failure of the prosecution to show to the court that one of the accused,
don't you think that your witness confirmed that the place where the logging happened is within the confine of the forest reserve forest reserve?
Yes, Tuan, but also the prosecution witness agreed that the forest is a huge area. So it is essential to specify exactly where the alleged offense took place.
But the indisputable fact is that it happened within the forest reserve. Am I right?
Yes.
Okay.
But, yeah.
Yeah, please proceed.
Okay. The last ground, which was on the failure of the prosecution to show to the court that one of the accused person committed the act and the others participated in furtherance of the common intention in accordance to Section 34 of the Penal Code. Section 34 of the Penal Code explains that each of several persons liable for an act done by all in any manner if done by him alone. And when a criminal act is done by several persons in furtherance of common intention of all, each of such person is liable for the fact in the same manner as if the act were done by him alone. Okay, proceed to paragraph 41. Okay.
Why you're submitting on Section 34?
Because when
there's only one accused person,
the defense did raise out the issue such as the conduct of Mr. Mark Angus, Mr. Mark Angus, who shows who was being very cooperative, which is as agreed by the
true. I agree. I appreciate that. It came out on evidence and all that. Fine. But you're also aware that that there's a Section 32 pointing at you guys, correct? Your person can be prosecuted for the act of an agent. Okay. And also, Alan Kusuma is the CEO of the company of Suka Lok. Am I right?
But there will be another allegation which requires for the prosecution to prove that the other employees were also had the common intention.
Okay. Anyway, doesn't matter. Yeah, proceed, Aiman.
Okay. Mr. Solicitor, could you scroll to the conclusion? Yes, straight away conclusion. Okay. Okay, thank you. Okay. Tuan, we would like to proceed with the conclusion.
Sure.
Okay. We humbly contend that the prosecution has failed to prove the act of cutting and collecting the forest produces were done by our client. Referring to section...
Don't use the word client, by the accused.
Sorry.
Yeah, accused.
By the accused. Sorry, if I may restate that statement.
Sure. No.
We humbly contend that the prosecution has failed to prove the act of cutting the trees and collecting the forest produce were done by the accused. Referring to section 182, capital A, subsection 3 of the Criminal Procedure Code, if the court finds the prosecution has not proven its case beyond reasonable doubt, the court shall record an order of acquittal. The defense believes that the accused has reasonable doubt on the evidences admitted by the prosecution to conclusively to relate the accused business to the alleged offense. There is a gap in the chain of evidence by the prosecution to point to the guilt of the accused.
Aiman, before you conclude that thing, let me ask you a simple question. Zoom in straight to the ingredients of the charge. Okay, particularly focusing on section 32. Have the accused person taken reasonable steps and don't have any knowledge of that the permit is a fake permit and all that? Have you taken steps to verify the authenticity of the fake permit? Authenticity of the permit.
Yes, Tuan.
What steps have you taken?
Instruct.
From what has been told by Yvonne. What are the steps that have been taken?
That is all actually that the accused relied on. The accused relied on his knowledge that his operation manager had done the verification with Mr. Bonaventure, and also the accused ensured that
Bonaventure was not brought in, right?
Yes.
Because he died.
Yes.
Did any question be imposed to the IO in respect of Bonaventure? Whether any statement were taken by the IO?
No.
On Bonaventure? Have the defense cross-examined?
No, Tuan.
On that evidence? No?
No.
It's a missed opportunity, isn't it?
Yes, Tuan.
Okay, now mind. Proceed.
Okay. Mr. Solicitor, could you scroll to para 45? Okay, sorry. Hence, the prosecution has failed to conclusively to prove the act of cutting the trees and collecting the forest produce were done by by the accused. Based on the contentions above, we pray to the court for the acquittal and discharge of the accused. That is all, Tuan.
Thank you. Thank you, Aiman, for the submissions. I appreciate your clarification on the submissions they made. Okay. Herein, we will stand down the matter. If there is no, before that, prosecution, do you have any reply to the contention of the defense during the submissions? A short summary will do if you need so.
Yes, Tuan. We'd like to address each of the elements of the charge because that is the order at which the defense counsel has submitted.
Okay.
The first, as they have pointed out also, they did not dispute the fact that there was an act of cutting down the trees.
But what is about their contention that that it's not being fair? Prosecution have not proven that it's a forgery by making the evidence known to the parties. How you determine the forgery of the document? Is this their contentions? You see, it could be violating the competition rules. But what say you?
Well, it is our submission today that there was a forgery because if an application was made to the forestry department and if they had went through the form 11A, they would not have approved it. And the reason why we say that is because there's a clear discrepancy between the form 11A and the statutory document, which means the person acting on behalf of the chief conservator of the Sabah Forestry Department would have picked it up, and he would not have approved it. The fact that Eunice Marlis...
Why don't the prosecution bring in Eunice? Forget about Bonaventure, because he passed away, but at least you should have attended the Bonaventure statement through the IO.
Tuan, do you mean Eunice Marlis' statement?
No, Bonaventure statement.
Bonaventure statement.
You all must understand that when these people got arrested, Alan Kusuma got arrested, at that time Bonaventure was still alive.
Yes.
Am I right? Check the facts. You see, he only died 1 month after the arrest. So at that material time, he was still alive. So his statement would have been recorded by the IO.
On that point, Tuan, we are not disputing the fact that Mr. Bonaventure actually existed as part of the Telupit Forestry District. We do not dispute that. He was part of our, apologies, he was part of the establishment at which the first and the second witness work at, which is the Telupit Forestry District. It is our contention that he never met with the second defense witness. The conversation between them never occurred.
Yeah, that is understood. Was there any evidence from the IO to say that he never met?
No, Tuan.
No, isn't it?
No.
Okay, fair enough. I understand that. And the very reason why the people never brought in the Eunice also because you are bound by the rules. Am I right?
That is right.
Okay, that is your contention. Okay, fair enough. Proceed.
That is on the validity of the permit. On third, the defense is also not contested on the issue that the occurrence of this crime of cutting the forest trees happened within a forest reserve. They have agreed to that. explicitly. There was no contention against it. And finally, with regards to the defense submission that Mr. Alan Kusuma wasn't there in Tangkulak Forest Reserve, and as such, he cannot be held accountable for the actions. It is the prosecution submission. To sum it up, he acted through his agents, even though he wasn't there directly.
That is the law, isn't it? That is the law that you all are relying on.
If the defense wants to rely on this contention, they would have to prove to the court that he had no knowledge or he had exercised due diligence, which is our submission that he did not do that.
Okay.
Tuan,
anything else, Mr. Jaya?
No, Tuan, that is all.
Thank you so much. Okay, for everyone who have submitted before us and appraised her on the facts and evidence. We shall stand on the matter. Mr. Interpreter, where's Mr. Interpreter? Yes, Mr. Adam.
Yes, Tuan.
Yeah, Mr. Adam, what is how the process goes? We stand on the matter, right? Before
Yes,
deliberations.
Yes, the court will
How long
take
the deliberations? How long the time allotted for deliberations? It was somewhere there.
15 minutes break for the deliberation, and then
sorry, I didn't follow you. 15 minutes?
Yeah, 15 minutes break for you to prepare for your deliberation.
Okay.
And after the break ended, you will give your deliberation.
Okay,
and
after 15 minutes.
Yes.
Okay. Okay.
And after that, the court will
so the parties will converge back after 15 minutes. Am I right?
Yes.
15, 1-5. Okay.
Yes.
Okay. So yeah, please go and have a quick lunch or whatever. I'm sure you all are hungry. Okay, so we will regroup after 15 minutes. All right. Mr. Adam will guide us. All right. Thank you. Thank you. Thank you.
Terima kasih, Tuan.
Thank you.
Tuan.
Mana Putri? Okay.
Sorry, the break has ended. The 15-minute break has ended. If I may know, is everyone here?
Um, Adam,
Yes.
please do allow me another 5 minutes.
All right.
Okay, thank you.
Okay, we resume the break for 5 more minutes.
Yes.
Oh, okay.
One. Before Tuan Salim get ready, if I may know if everyone here, is everyone here? This prosecution and the defense side.
Yes, we are all here.
Salim, are you there?
Can
Yes, one. You may proceed with the deliberation.
yes, everyone here. I'm sure that you all have taken a lunch and a quick break, and a deep breather. Okay. Yeah. First of all, let me deliberate. Based on the guided rules, based on decision of the courts, of the superior courts, guided by the rules of law, I have taken into account the submission made by both parties. And though it's a competition, I am bound to announce the decision of the court on the merits and substance of the charge. Herein, I find that prosecution have proven their case beyond reasonable doubt at the end of defense. Herein, I convict the accused person and sentence him to a fine of 500,000. Prosecution, perhaps you could assist me. Is there a mandatory imprisonment here?
Yes, Tuan. The court has the discretion to choose between 1 year imprisonment or less than 20 years of imprisonment.
Since there is a mandatory imprisonment in respect of this charge, herein I sentence the accused person to a minimum of 1 year imprisonment and 500,000.
Much obliged, Tuan.
Ladies and gentlemen, be that as it may, upon convicting the accused person, now we come to the reality of the show. That this is a competition. We are bound by the competition rules, and first and foremost, and in an informal setting, I would like personally to congratulate each and every one of you who played a role, both as the interpreter, prosecution, defense counsel, and witnesses, and including instructing solicitors. Okay, who played a marvelous role in showcasing us the opportunities that made available for you as a defense counsel in a limited role, or prosecutors in a limited role. Okay, that is tremendous. And as I reiterated earlier, although both your hand and feet are bound, okay, and being pushed on to in a water, but you managed to swim through. Okay, and it's not an easy task. Let me tell you. Let me reiterate further that you all have done the best what you could within the framework of what been given to you or thrown to you. All right? So congratulations again. But just like any other competitions, there'll be a winner and loser. But let me congratulate that both of you, on a moral basis, have shown a tremendous courage, exemplary talent, and both are winners in their own cause. But unfortunate, I've been bestowed to announce the actual winner of the day, right? The best instructing solicitor. I am not going to announce the best winner now, or best institutions that are going to win, because eventually, you will able to digest from the way I announce the individual winners, okay, of what the competition will be. Best instructing solicitor goes to Ms. C. Jiawei with a score point of 76.
Much obliged, Tuan.
Best witness goes to Ms. Tan Boon Wei of a score point of 80.
Much obliged, Tuan.
Best counsel goes to Mr. Jaya Ganesh with a score point of 87.
Thank you, Tuan.
Best overall performer goes to Mr. Jaya Ganesh.
Thank you, Tuan.
Congratulations. And the clear winner for the day is Multimedia University. For UITM, my congratulations to you. Keep your spirit up, okay, for the future competitions. Okay, more trainings have to be put on, okay, for you to to come back stronger. Inshallah, you'll be merging victoriously in future. Okay, right. And I was also being tasked to inform, to advise some of the key points that you need to take it to heart while you're conducting your trials in the future, or also for the purpose of your competitions thereon. You see, one of the things that I've noticed is in an actual practice, in natural proceedings, all documents must be exhibited before being referred to the witnesses. Okay, what I've been seeing is the bundle of documents being passed on to the other sides, and you keep on referring it on the online systems. Okay, even if it's taken out on the online trials, okay, whether civil or criminal, each individual documents must be admitted individually, more so in criminal trials. Okay, in a civil trial, they have agreed common bundles and all that. That is fine. But in a criminal trials, okay, even if you want a document being exchanged, but each document must be proved on its own. In other words, the admissibility of the evidence must be proven through the essential witnesses, okay, for it to be marked as an evidence in court. In absence or failure to mark that particular document through witnesses, then you must allude to attempt to mark it as hearsay document and take refuge under section 32 of the Evidence Act. Okay, always remember that. Okay, and how you do that? If you do not have available witnesses, you try to bring in under section 32 ING. And for the purpose of this competition, if any one of y'all would have alluded to that, I would have allowed it, because you are bound by the rules and you cannot bring in witnesses. Therefore, you can take refuge of section 32 ING. Okay, if you don't know what is ING, never mind, go back and take a read. Okay, section 32 ING of the Evidence Act. Okay, so you can take refuge of that. Okay, and bring in the evidence through the IO, because prosecution had brought in the IO, so you can actually use that. Okay, right. But you must be proven. All documents must be proven. You cannot just show it and then without proving the document. For example, like the photographer, you are bound by the rules of competitions. So I have no issue, no qualms about that. And although I didn't mark it as an exhibit, but in future, remember, even you have a section 98 certificate, you still have to prove it by way of bringing the photographer. Okay, I bring in the photographer will bring his pen drive. Nowadays, the camera and all that, they use the digital camera, correct? So you use that particular SIM card, I don't know what you call that. Okay, and then you tender section 98 certificate. If you cannot bring the person who actually print out that particular photo. Okay, there's always a situation of one person taking in a photo, another person is printing it out. Or can be also a situation of the same person taking the photo and the same person printing it out using his own computer. Okay, if that person comes in, then it's fine, fair enough. No need to tender 98 certificate as Nana Segrin's position. Okay, but if the different person comes in, then you are bound to tender section 98 certificate. Okay, but you must try to satisfy the evidential burden under section 98. Okay, right. Now, a witness statement. I don't know why witness statement was not allowed to be tendered. But in order to satisfy section 402, the witness statement must be tendered because it's a proceedings in court. The only difference is we are not doing it orally. We are doing it by way of a witness statement. Okay, only the cross-examination is done by orally. Okay, so for the purpose of the admission of that piece of evidence during examination chief, okay, either prosecution or defense, okay, that particular witness statement must be exhibited in court. Okay, either prosecution evidence or defense evidence. It must be exhibited. In absence of that exhibition, basically there's no evidence in chief. Okay, so careful of that. And I don't know why. Maybe there is a reason behind this this suggestion of not wanting to tender. I don't know why. That is up to the organizer. But in a natural proceedings, it have to be tendered. All right. So please keep that in mind. Okay. Defense have mounted an attack that the accused person should not be responsible if he doesn't actively participate. Okay, or not being at the crime scene, or he didn't procure the illegal logging, but overlooking the requirements under the law. The requirements under the law, the prosecution just have to prove that that he have authorized the agents, and all the agents are working for him, and that they have managed to do that. Okay, where we have a witness evidence. Okay, and nobody disputed they never worked for Alan Kusuma or the company. Okay, so by virtue of the fact that no dispute in respect of that piece of evidence, it is admissible that that he is person responsible. He is the person. He's the CEO of the company, and he is everything that being done by the agents are under his authorization, his supervision, his permission and they all are the workers of the company. With that said, the ingredients of section 32 for the prosecution of Alan Kusuma is satisfied. Okay. So defense should have taken note of that. Okay. Okay.
you see, when certain evidence being thrown in, witness statements and all that, there is a discrepancy at times. Okay. Typographical, that's acceptable. But when there is a discrepancy in terms of evidence, okay, of the witness statement and documents, that you call discrepancy in evidence. Okay. That evidence, okay, you can correct the witness statement, but you cannot correct that particular piece of evidence. Okay. The documents, whatever content of the document, you cannot what do you call that, rectify. Okay. But the witness statement you can rectify. Okay. So always remember that if you want to rectify or you want to make amends, you can make an amendments to the witness statement, not the evidence. Okay. Evidence means documentary evidence. For example, like the borang, whatever, 1 something, if there is some discrepancies there, it remains. There can only be explained by the forestry officer or any witnesses for the matter. Okay. In relation to that document. Okay. But you cannot correct that document. Okay. In court proceedings. Understand that. Okay. For example, there is sometime typographical error in a police report. That police report, it should only be corrected by way of making a, who knows? How you do that? How you correct a content of a police report?
By making another report.
That's true. By making another fresh report. You cannot come to court and say that, typo, liquid paper, or you make, initial, delete the dates or time or whatever. You cannot do that. Okay. It's evidence. We have to be very, very careful. Okay. So you make a fresh. Understand that. Okay. Good. Okay. Then, this is Jaya. Jaya, you have won as a best counsel. Okay. But ethically careful of your drinking. But not drinking per se. When you take a gulp of water in the court, okay, make sure even it's online, the judges watching or your colleagues watching and all that. Okay. Even I understand, thirsty and all that, seek permission. Okay. Seek permission from the court. Okay. Because I've been observing. Yeah. Seek permission. Okay. And then in a real courtrooms, you cannot face the judge and drink. Even when you got a permission, you must turn and drink. You must turn your back. Okay.
Understood,
don't face the judge. Okay. So that is a small thing that you need to observe. Okay. Other than that, okay, cross-examination. Okay. Defense, you should have gone a bit more assertive in cross-examination. As I said, you should have put relevant questions. For example, like this Bonaventure, although he passed away, no doubt about that. But within the 1 month gap, statement would have been recorded. So you should have put that kind of questions to the IO. Okay, the witness 2, prosecution's witness 2. Should have put that question in. Should have grilled him further. Okay, what is Bonaventure's witness says? Something to that effect. Because he passed away. Okay. Okay, and then also this Eunice. Okay. So question, although Eunice was not secured to be a witness, but that is not a fault of the prosecution because they are bound by the equal competition rules. But but defense should have gone further, cross-examine on Eunice, okay, on challenging that particular piece of evidence, and also challenging the fact that that what the prosecution is saying is fake and all that, is false and all that, not true. No arguments or cross-examination were premised on that. Okay, so I know you all will have to work within that framework of law. The prosecution had a better leverage to a certain extent when it comes to the facts of the case, but defense should have been made better by way of cross-examination. But always remember, even as a defense counsel, all the time we are facing bad facts. Okay, only now, at least now we have 51A requirements where the documents are given to the defense before the trial starts. Those days, I'm talking about 20 over years ago, we don't have anything. We only be given a charge sheet. One simple charge sheet. That's all. That's all. No matter how, whether it's a murder, drugs, or any case for that matter, we only given a charge sheet. You see, now at least we have the privilege of getting all the document under 51. Okay, where at least we can read, we can prepare, even with this witness statement and so on, at least we know what the witness is going to say, you know. But those days, no, only, I remember those days I'm going to court and all that, you know, only with a charge sheet, you know, only there's 25 years ago and all that before these amendments, you know, yeah, that's how criminal lawyers cross-examine those days. That is in 90s. Okay, so always beware, you know, at least you have the privilege, you always get the bad facts. Some we win, some we lose, but we do our best. We do our best without fear of favor, and we work within the framework of law, evidence, and procedure. Then you become better. It's not a battle actually. You're just doing your best. End of the day, seek justice. Okay, or don't take it too hard. You know, just do your best for your client that you represent. Okay, and the duty of the prosecution is to lay out the evidence. They also not out there to prosecute and kill him actually. Okay, they cannot prosecute at all costs. They are just out there on behalf of the crown. Okay, lay out the facts and evidence. Okay, and duty of the counsel to actually to withdraw. Okay, it's like a jigsaw puzzle. You know, they build up the case. You just have to withdraw one cube of that particular jigsaw puzzle for the entire case to drop. So that what duty of the defense is, right? On a balance of probability. Okay, right. Okay, when it comes to when a defense is called, remember Daniel, Ayman, okay, Danish and all that. Remember, and all of you, remember you must inform the court. What is the mode of evidence that need to be given? I know the competition rules say that it must be given on sworn, it's a sworn statement, okay? Sworn statement. But at least you must inform the court, it is given on sworn statement. Okay, the evidence will be presented on a sworn statement. Okay, because we have unsworn statement also. It's a piece of evidence. Do you all know what is the difference? Unsworn statement, okay, he just read it from the top. He just read it. Like a witness statement, he just read it. The Alan Kusuma just read it and not subject to cross-examination by the prosecution. Prosecution cannot cross. Okay, and another one, which is a defense, but non-existent because of amendment section 180 of the CPC. Unrebuttal warrants a conviction. That is an amendment. Okay, and section 180 of the Criminal Procedure Code. So therefore, that particular the third defense exists, but it's taken away indirectly. Okay, that is right to remain silent. Right to remain silent is there and taken away. If you look at the case of PP against Aris Najib, you know, the murder of that Chinese lady in Bangsa shopping complex. What's the name? Ahmad Najib Aris, the Chinese girl, Kenny Ong's case. Look at the case. Go and read the case of PP against Najib Aris. The defense is there. But unfortunately, because the lawyers took right to remain silent, the accused person don't want to speak anything, they have to convict. Unrebuttal, warrants conviction. After the amendment. Before the amendment, can you can utilize that defense. Now can't. Okay. So remember. So you only left with the two. That is sworn statement, like what been given by Alan Kusuma. And second is an unsworn statement, not subjected to cross-examination. It's both an evidence. But just that the second one, the weightage of that evidence is lesser because you have no opportunity of cross-examination by the prosecution. So you cannot test the water, cannot test the veracity of that evidence. So the weightage is lower. Understand that, everyone? Okay. Now, yeah, I think generally, that is that. Okay. Unless you have any questions, one question or two questions which I could answer, then feel free. You know? Yes.
Earlier, the first thing you mentioned
who is asking? Oh, Jaya Ganesh. Yes.
Earlier, the first thing you said, you have to adduce all documentary evidence. Even if it's in statutory form, you still need to show it to court.
all documentary evidence
Needs to be shown as evidence in court.
Oh yes. Oh yes. In a criminal law, there's no such thing as your counsel, Mr. Daniel, agree, or therefore it can go in. It doesn't work that way. Okay. Civil, yes. We have part 1, part 2, part 3. Huh? A, B, C. Agreed document, non-agreed document, agreed document, but call the maker in part 3. I don't know what's the difference there. Okay. So you have all that in a civil trial. In a criminal trial, we are strictly adhere to the rules of evidence. Only for the purpose of this competition, we say no, okay, no problem. Okay. But in a strict natural proceedings, you have to adhere to the strict rules of evidence. Not only 51A, but also the admissibility provision under the Evidence Act. So you've got to call the maker, whether it is a primary evidence, whether it is a secondary evidence, whether it is subject to section hearsay rules, all that must be complied before the document can be deemed admissible. Okay, and always remember, you must also appreciate what is the difference between exhibit and IDD or ID. Okay, IDD defense exhibit, ID for prosecution. Okay, basically ID is just a reference. The court cannot take that into consideration when it comes to deliberation. It's just a piece of paper. It's just a blank piece of paper. If you can see, it's just a blank piece of paper. This is ID. Okay, exhibit is this. You understand? This is the exhibit. I must take into account what is here. Okay, but ID means even you tender this with these writings, as far as the court is concerned, is this. Okay, remember. Okay, always remember. That is why lawyers, we want to make it into account as part of evidence when it comes to deliberations. All right, until the court of the highest court. Okay, we want to be exhibit. Okay, thank you, Ganesh. Thank you for that. Any questions? One more questions?
I have.
We're running out of time actually. Yeah.
Oh, sorry.
Or any other questions?
Okay.
I feel free. I'm okay. Yes, Lim.
Can I have? Oh, okay.
I wanted to ask, do you have any personal comments for us? And are there any tips for us to improve on our advocacy skill?
Yes. Lim, you are okay. Compose. Okay, good. Okay, but be confident when you're presenting and all that. And you have to adhere to the way how, for example, like trials. Okay, once you come into the profession, you can see, when it comes to trials, okay, you must know how to present certain documents, how to actually go slow. You can take cue from what Jai Ganesh. If you all want to know why I give Jai Ganesh a higher score, is he was composed and he took the court step by step. Okay, introducing the document, you say, is this your document? Okay, can you verify the document? Can you see the document? And then in a certain cases, you can see, can you, how you identify the document? So the witness will say, yes, I just saw my document. It just simply cannot say, I saw my name here, cannot. I verify the document because of my signature. Where is your signature? My signature is in page 3. And then you look at page 3. That's how you go step by step. Okay. So Lim, you are at the initial stage when you're cross-examining examination chief for the prosecution witness 1. Maybe you just started or something, you are not so composed. Okay. It was all over. All right. But later on, you picked it up. Okay. So my suggestion, whether it is a civil case or criminal case, go slow, step by step, because every piece of evidence is important. Okay. People have gone even to federal court to challenge, witness statement. My own case. We have taken it to the Court of Appeal in federal court, challenging it, witness statement, which was not read by the witness. Not public prosecutor against Fomi Aftab. That is my case. I did that case in the Court of Appeal. Okay, where challenge was mounted. Okay, where the chemist came to court and she didn't read the witness statement. It was tendered as an exhibit.
It was tendered without reading. They assume that everyone, got the document. Okay. High Court, they never read. It was tendered without. So as far as the court is concerned, no evidence being read. Only now you have to actually, even they don't read also, you can. Because that time the amendments have not taken place back then. Every piece of evidence have to be read, even through a witness statement. Okay, these 402B and all that, they have yet to exist at that time. Okay, but even now, if you want to tender a witness statement, it have to be read by the witness, no matter how lengthy the thing is. Ad verbatim, ad verbatim. Okay, so that is in respect of Lim. Okay, Jai Ganesh, you did well. You composed, very composed. And the thing that attracted more marks is when you are submitting. Okay, you didn't say that I will come to that later. That is always a problem with some counsel, some lawyers, most of the junior lawyers and all that. Okay, they have a structured submission, and as they go through the structured submissions, when we stop them, we interject. When the judges interject and ask them, they will say that we yet to come to that. I will come to or address that point shortly. That was the biggest mistake. Jai Ganesh escaped that. He escaped that. He managed to interact with me at any juncture when I interject, and he managed to clarify. Though he got other points that he have wanting to proceed. Okay, but he have answered the question as and when the question being posed to him. Okay, right. So that is important, and I hope other councils also could take cue of what being explained. Okay, or what happened. Okay, for your future. For your future, you must be able to interact, because when you go to Court of Appeal and Federal Court, when you do the submissions, the judges don't care at which paragraph you are. They read your submissions. They will just come and boomerang you, and you must be ready. You must be ready with your facts and figure, and you must know what is happening. You must know the entirety of your submissions. Even sometimes the question will be asked outside your submission. You must be able to relate. Okay. Okay, so be aware of that. It's not a question of reading it. It's a question of you submitting it, and you must be cogent and confidence of your case. Therefore, you can able to interact with them at any stage, at any juncture in the course of your submission. Okay, right. So that is that. Aiman, you focused too much on cross-examining the photographer. The photographer is irrelevant witness. The issue of the photograph is irrelevant because they used an aerial or something, that they are drawn, isn't it? It's another word, they use drawn, isn't it? So they only actually took an aerial view, and then they found out these boys and all that, the workers and all that were there at the ground. Okay, they didn't actually capture the photograph there from the sky. Okay, it's only after the arrest that the picture, the forest department went and captured the logs and all that. Okay, so that sort of attack, it's doesn't help much. Always remember, in a cross-examination, it's like pulling out lion from the den. If you're not careful, the lion will pull you in. Okay, so you must know what question you're going to pose, the relevancy of the question, careful of the question. Okay, if you're not careful, it'll be a double-edged sword. The prosecution can take advantage of that question. Okay, so defense counsel, watch your question. That's why those days and all that, senior counsel, they only ask 1 or 2 questions. That's it. But I don't encourage that. I don't encourage that unless you have attained a certain level of experience, or else you will all the evidence cannot be not challenged. Prosecution will argue this evidence not challenged, this evidence not challenged, because no cross-examination. Look at the case of public prosecutor against Wong Sui Chin. What did Wong Sui Chin say? This is a Bota Chin's case. Untested question, the untested evidence is deemed acceptance. That means you didn't challenge. You must put forward all this challenge. You want to challenge fraud, forgery, appa, no problem. Challenge it. Put forward that question. So long it's relevant to your case. Even if the apple is relevant to your case, put that question in. Understand? So that is the cross-examination that you must pursue. Pursue it with confidence and vigorous. See? You challenge the witness evidence. See? But be careful of your questions. All right, Daniel, you're quite slow in your progress and all that, quite calm. Okay, but you have to have more confidence. Yeah, be more confident in your presentations. Okay, have a structured, prepare for your case. Okay, not so much on the competition, but when you face a real case in life in the future, I'm sure all of you are the final year. Is it? All of you are final year students? No, final year. The first year. Second year.
MMU, all final year.
All final year?
MMU, all final year.
Oh, MMU, all final. UITM?
No, sir. We are not in our final years.
Oh, you all also in the
No,
final year?
No, we are not in our final years.
What year you all are?
In our third year. So we
Third
have another
year.
one.
Okay, 1 year difference lah.
Yeah.
So not so bad. You know, not so the difference is not so fine. I think just that they had the advantage. Maybe they have read the procedural papers lah. They have done the procedural papers, whereas UITM yet to do procedural papers. Am I right? Okay.
Yes, sir. Betul.
Yeah. So yeah. So that is the only difference. But you all did fantastic. It's a good try. It's a good platform to begin with. Okay. Always, we see the students in the universities and all that public universities go for moot. Moot is actually nothing much. Moot is actually for senior lawyers to go and submit the Court of Appeal, Federal Court and all that. That is submission. This is what you have been doing. This is what matters. Where you learn the procedure, how to cross-examine. You learn from us, how the small nitty-gritty things, that you need to observe and all that. This is where the learning ground is. Because you'll be starting your practice. If you in future you're going to practice, you'll be starting in a magistrate court, sessions court. There are trials. We don't do our appeal. You see, the appeal is the high court and above. You see, so this is where matters. So you should be proud of yourself of taking this opportunity to train yourself. Winning and losing is for the competition. The life experience that you got from this is what matters. This is what matters. And I'm so proud of you guys, okay, that you all have taken it on your own, okay, with the little experience that you have, okay, maybe you're being taught by some of your coaches and all that, okay. So yeah, with that experience, you take it on board, and the will power that you all had to pursue this on your own, okay, vigorously, and all the hard working that being put on for the last, I think, 1 month or two, I wish you all the best. I'm so proud of you guys. I hope, I can see you all in the future. And I'm telling this as a former president of the Malaysian Bar. Is it? Yeah, and that I'm very proud of you all. And I hope to see you all in the industry. Okay. Thank you so much. Thank you, Adam. Thank you, everyone.
Thank you.
Okay. Adam is, I can't hear him all the time. He mutes. Okay. Are we having a photograph sessions?
After this,
online photograph sessions?
Oh, online photograph session? Yes, we can.
We can, huh? Okay. Yeah. That's for the memory. Yeah. Okay, guys. All the best, yeah? Congratulations.
1, 2, smile. 1, 2, smile. Okay.
Thank you. Thank you, everyone. Good luck. Good luck to everyone.
Thank you. Goodbye.
Thank you, Tuan.
Thank you, Tuan Salim.
Thank you, everyone.
Thank you, Tuan.
Thank you.
Okay,
Great session.
for the participants, all of you must stay in this room, in this breakout room, and later on, we will debrief you for the next round. Okay. All right. Thank you, Tuan Salim.
Thank you.